The purpose of this morning's meeting is to resume our pre-legislative scrutiny of the general scheme of the Assisted Human Reproduction Bill 2017. Previous meetings took place on the 17th of January and the 28th of February 2018. Today we will hear from two former members of the Commission on Assisted Human Reproduction, Professor Deirdre Madden from the School of Law at UCC and Professor Noreen Hayes from the School of Education, Trinity College. Miss Marion Barnard and Miss Gillian Keegan from the National Fertility Support and Information Group, and Miss Emma O'Reilly and Dr. Joanne Rose, who will speak from the perspective of some donor conceived perspectives. Just some housekeeping matters. On behalf of the committee, I would like to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect to their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any persons or entity by name or in such a way as to make him or her identifiable. I also wish to advise you that any opening statements you have made to the committee may be published on the committee's website after this meeting. Members are remembered of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside of the Houses or an official, either by name or in such a way as to make him or her identifiable. Can I now ask Professor Deirdre Madden to make your opening statement? Thank you.
Thank you very much. So thank you very much for the opportunity to share my views in relation to the general scheme of the Assisted Human Reproduction Bill. I have submitted a more detailed paper in relation to the bill, and at this point, given the short period available to us this morning, I would just like to highlight from that submission the area of most pressing concern to me in the bill, which is surrogacy. Surrogacy can play an invaluable role in helping to create new families, but it raises complex legal and ethical issues on which there are many diverse views. From a policy perspective, I think it's important to bear in mind that surrogacy is a present reality and that it must be dealt with by ensuring respect and protection for all parties involved, particularly the rights and interests of children. In my opinion, prohibitive approaches in this area will fail. We must not put our heads in the sand, but rather learn from what works and doesn't work elsewhere to craft an appropriate legislative model for this country. Developments in assisted reproduction mean that it's now possible to separate conception, gestation and child rearing with a number of different potential parents due to various combinations of gametes and roles. This challenges our traditional and cultural norms in relation to what parenthood is and what a family should look like. An important question that arises in surrogacy is who should be recognised as the legal parents of the child and why. In answer to this question, the bill proposes that a surrogate mother who is required by the bill to be genetically unrelated to the child she carries should be the legal mother of that child. This requires intended parents who are required to be genetically related to go through a legal procedure to gain recognition of that relationship. We know from some studies of surrogate mothers that surrogates generally do not consider the children they bear to be theirs and do not wish to be regarded as the legal mothers of those children. I submit that this proposed policy is not in the best interests of surrogate mothers, the intended parents, and certainly not the child. The Commission on Assisted Human Reproduction recommended in 2005 that the child born through surrogacy should be presumed to be that of the intended parents. This recommendation, which I support, was based on the intent of reproduction concept, which aims to identify those people who are most strongly motivated to have a child, have initiated the reproductive process without which the child would not exist, have been closely involved throughout the pregnancy, and have demonstrated a commitment to caring for and rearing the child as their own. In my view, this concept would provide the most consistent outcome in surrogacy cases and, most importantly, would prioritise the best interests of the child, as it would legally recognise him or her as the child of those who were highly motivated to plan and bring about its conception and who fully intend and desire to take on the responsibility to raise and care for it. I would urge members of the committee to examine the surrogacy frameworks in other jurisdictions where legal parentage is accorded to the intended parents prior to birth, rather than take the easy route of following flawed legislation from the UK, which has been the subject of extensive criticism in recent years from lawyers, judges, advocates and academics. In fact, the Law Commission in the UK is currently reviewing surrogacy law there, having taken the view that their surrogacy laws are not fit for purpose, yet we are proposing to copy those same laws. Payment of surrogate mothers is also an issue that provokes much debate. The bill proposes a model of reimbursement of vouched reasonable expenses. However, the consequences of transgression, in my view, are extremely harsh and expose the intended parents to potential criminal prosecution with significant penalties. Most importantly, transgression results in loss of eligibility to apply for a parental order. In these circumstances, the birth mother and her husband will remain the unwilling legal parents of the child to whom they are genetically unrelated. So I ask, how is this a child-centred approach? The reality is that in the UK, on which our scheme is now modelled, or proposed to be modelled, family courts always authorise payments to surrogates in excess of notional reasonable expenses so that parental orders can be made in the child's best interests. One of the UK's most senior family judges, Sir James Munby, recently called for a relaxation of the rules against paying surrogates, saying that it would be better to face up to reality, rather than have the law say one thing but accept another. The current proposals in this bill risk causing parents to mislead the court about payments and will cause huge anxiety to honest people who fear that their child will be removed from their care if they cannot justify the payments made to surrogates. So again, I ask, why is it proposed to copy the English model and insert a similar provision into legislation here that we know will similarly be ineffective and will be ignored by Irish judges in practice? It may be argued that facilitating payments to surrogates encourages commercialisation of reproduction, which can be exploitative of poorer women, and I fully accept that there are legitimate and important ethical concerns in this regard. However, the avoidance of potential exploitation will not be achieved by this bill. It will just ensure that it doesn't happen here. In my opinion, the appropriate response is not to put an unenforceable prohibition in place, but rather to insist on proper safeguards to ensure written agreements, counselling, screening and preparation. The bill does not attempt to regularise the situation of those couples who are faced with trying to bring their child back from another jurisdiction, which will be the reality for most families who choose to have a child through surrogacy after this bill. As the experience of other jurisdictions demonstrates, this may leave children in legal limbo, potentially stateless and parentless, pending the outcome of litigation. This bill will result in the birth of Irish children in other countries who will probably never know the identity of the woman who carried them for 9 months and gave birth to them. This is inconsistent with the right of the child to access the identity of their biological parents, as provided both by the United Nations Convention on the Rights of the Child and by our own Children and Family Relationships Act of 2015. I agree with the Chief Justice of the Family Court of Australia, Judge Diana Bryant, who described it as extremely irresponsible for governments not to deal with international surrogacy arrangements. In my view, therefore, this bill cannot be described as child-centred, and I would urge the committee to recommend to the Minister that it be revised. Thank you.
Thank you very much, Professor Madden. Could I now ask Professor Noreen Hayes to make your opening statement? Thank you.
Very much. Thank you very much for inviting me to present my observations. As a member of the Commission on Assisted Human Reproduction, I welcome the publication of the bill. My background is psychology, and professionally my focus is on early child development and education. I'm a founder member of the Children's Rights Alliance and approach my work and my research through a children's rights lens, which holds that children of every age are independent rights holders, a position now captured in our Constitution. The Committee on the Rights of the Child is clear in their guidance that implementation of the Convention on the Rights of the Child requires states continually to review how law, policy and practice affects children's rights, and it's in this context that I make my observations. I cover 3 particular issues: the design of the bill, the welfare of the child and the child's right to identity, particularly in surrogacy. In respect of the design of the bill, the intention behind assisted human reproduction is in all cases the safe arrival of a child. And I believe that the current design of the bill could be strengthened by a more robust child rights approach. Such an approach would draw attention to the need to realise and protect children's rights at all stages in their childhood and take account of their views in keeping with Article 12 of the Convention on the Rights of the Child. It would also provide a basis from which to address the central role of parents in protecting the rights of their children and states' responsibilities to support them in this regard. The issues raised are particularly relevant to the surrogacy, where due attention must be paid to the developmental needs and rights of the very young child. Under Article 18 of the Convention, parents are recognised as having primary responsibility for the upbringing and the development of children. Article 18(2), however, notes that state parties shall render appropriate assistance to parents and legal guardians in the performance of these responsibilities and shall ensure the development of institutions, facilities and services for the care of children. The bill should therefore endeavour in its design to support parents in protecting children's rights to know their parents and be cared by them, and their rights to have their views taken into account. The Committee on the Rights of the Child note that the views expressed by children may add relevant perspectives and experiences and should be considered in decision-making, policy-making and preparation of laws and/or measures, as well as in their evaluation. But how can that latter right to participation be realised at birth? The Committee note that in relation to the totality of the CRC, the participation can be addressed by using reliable data on and from children to identify and inform all policy development for children. There's a growing population of children and young people who are the direct outcome of assisted human reproduction procedures and over their lifetimes can offer insight into how policies and practice have affected them and could be changed and improved. The current bill only references research in terms of medical research. I suggest it be amended to include a recognition of the importance of social science research into the lives and experiences of children born through AHR. The bill specifically attends to the welfare of the child, noting that AHR treatment may be provided subject to a consideration of the welfare of any child who would be born as a result of the proposed treatment. Relationships are a primary mode through which children develop, and the effect of the relational process is often more powerful than that of the context within which it occurs. Living in environments characterised by chronic, poorly managed stress has a direct impact on early brain development, especially in the weeks and months immediately after birth. Stressors in early childhood can disrupt neurologic, metabolic and immunologic systems, leading to poorer developmental outcomes for children. Where parents experience stress through uncertainty or lack of clarity around the security of their role as parents, the environment within which children are developing may be unnecessarily stressful. Proactively supporting the development of positive relationships between adults and children requires careful consideration of the relationships that happen in the lives of children and the factors that can contribute to enhancing or challenging the quality and impact of such relationships. The bill may be contributing to stress in the lives of parents and children. For example, in the case of the proposal's resurrogacy, the explanatory note identifies 3 stages of counselling: before the agreement, after the birth of the child, but before the child is living with the intending parents, and at the time of the application for the transfer of parentage of the child. These requirements could span a period of up to 6 months and seem onerous, adding a dimension of uncertainty around the precise parentage of the child. Such distress could have a negative impact on the child. Providing for judicial pre-authorisation where legal parenthood is granted to the intending parents before the birth of the child would provide clarity and certainty from the moment of birth, thus minimalising the stress in the immediate environment of the child following birth. The child's right to identity in cases of donor-assisted human reproduction is protected under the Children and Family Relationships Act 2015. However, the Act makes no explicit reference to the issue of the right to identity in relation to surrogacy. In light of this, it is critical that the bill makes clear the right to identity and the procedures to ensure the realisation of this right for children born through surrogacy. In this regard, the bill proposes that children born through surrogacy be issued with a surrogate certificate. I use this simply as an illustration of a point. In the rights-based bill, efforts would be made to ensure that the language used would limit the degree to which proposals create situations where children stand out as different from other children. In this regard, and to limit the emphasis on any particular type of birth, I would suggest that the surrogacy certificate proposed be retitled a birth certificate, and in brackets by surrogacy if necessary. In conclusion, this bill is a welcome step on the path to regulating for safe AHR environment for in Ireland for parents and children. However, in its design, it highlights welfare considerations without due attention to the rights of the child, particularly in relation to supporting the realisation of children's rights across their lifespan, identity and surrogacy, and support to parents to protect and realise the rights of children. Thank you.
Thank you, Professor Hayes. Now, on behalf of the National Infertility Support and Information Group, I'm not sure who's making. Gillian,
yeah, hi.
Your opening statement, please. Thank you.
Okay, great. First of all, I just want to say that I appreciate the opportunity to participate in this pre-legislative proceeding related to the general scheme of the Assisted Human Reproduction Bill. I'm Gillian Keegan, and I've been involved in ISIC for over 10 years, and I'm just basically here just to represent the organisation. The statement that I'll just give is just kind of briefly in terms of I suppose, the concerns of the membership, because obviously we provide support groups on an ongoing basis, and obviously we deal with people who are obviously going through these challenges over the last 30 years. Just to give you a brief detail in terms of what the National Infertility Support and Information Group is, it's a patient group formed in 1996 and is the only registered charity in the Republic focusing on fertility. Basically, if we encompass our mission, it's basically to provide practical and emotional support to and advocate on behalf of those experiencing reproductive challenges, and basically also to provide support to families who have used AHR. So it's not just pre, it's also post, and we have been developing those services, particularly over the last few years. We provide obviously support at all stages of the journey, from trying to conceive to IVF, through donor conception and through surrogacy. And obviously the landscape in terms of AHR has become quite complex over the last 10 years, and obviously we're trying to represent that in our group. One of the key things that we do provide, and I do facilitation at meetings where people come obviously who are having troubles in terms of having children, is really peer-to-peer support and also networking. So meeting people who are in similar situations to themselves probably makes it less isolating and also allows them to, I suppose, get emotional support from other people. The other thing I would say is that, as I said previously, is that NISIC also supports families created through AHR. So, for instance, we ran our first family conversations event about a year ago. And basically what this aims to do is basically to support families of donor-conceived children who are starting to discuss their children's origins. Okay, so we have obviously developed our services over the last few years. One of the things I would say, I suppose, about NISIC is that funding is critical for our organisation to continue to provide these services. And we have found, just as an aside, that funding has been particularly challenging over the last few years. We were getting National Lottery funding, but unfortunately we haven't got that in the last few years. I just want to focus on one or two things, and I suppose what I would obviously say is that as an organisation, that we certainly would welcome the overdue forward-thinking legislation and welcome the proposed introduction of a regulatory body. And obviously we have had acknowledgement that patient voices will be included on that body, which we obviously welcome. One of the things I suppose that NISIC has obviously concentrated on over the last 10 or 15 years is really to lay the groundwork for public funding for fertility. Given that obviously 1 in 6 people will obviously suffer from fertility issues, Ireland is only one of 3 countries, including Lithuania and Cyprus, that does not currently have public funding. And what we would obviously say about the sector in Ireland is that it has become increasingly commercialised over the last decade, and with the lack of public funding and also I suppose the entry of multinational companies into the sector, it has meant that those people who are obviously going through fertility treatments are open to exploitation, and it is hugely costly for anybody going through treatment, particularly obviously where they're doing repeated cycles. So we would ask the following things. We would ask that consideration be given to the number of cycles that may be publicly funded, and we would suggest that maybe 3 cycles would be reasonable. The other thing we would say is that in terms of funding, I suppose at the moment, and we've seen this evidence in our support groups, is that obviously a significant number of people travel abroad where certain treatments are not available in Ireland, for instance, double donation, embryo donation and egg sharing. And we would ask maybe, is that going to be considered in terms of funding, because that is obviously a significant issue. And we'd also ask that in terms of secondary infertility, that funding be considered in that case, and also in terms of the transfer of frozen embryos, where people are obviously hoping to expand their families. In terms of counselling, I suppose as an organisation, NISIC, that provides emotional support through our 24-hour helpline and obviously regional support meetings, we would certainly recognise the inherent value of counselling for those undergoing fertility treatments, particularly at points in treatment where I suppose treatments have failed, and also particularly in relation to donor conception and also in terms of surrogacy. Because what we find at our meetings is that people do a number of treatments and then they may have a conversation with the clinician where the clinician says, look, you know, if you want to have a family, you may have to consider donor conception. And that's certainly a huge blow for people when they hear that, and it takes quite a long time to come to terms with that. And what we would obviously say is that while counselling should be encouraged, it should not be arbitrary. Okay, so we would say that obviously it certainly is beneficial in situations where donor conception and surrogacy is considered. But we would obviously also say that it might be best where it's basically separated from the treatment provider. The other few things that I suppose I just want to mention is that obviously in the bill it's concerning obviously the upper age limit of people in terms of women in terms of undergoing IVF treatment, where it states that it's going to be for age of 47. We would kind of consider that to be unnecessarily restrictive, particularly as reproductive practices continue to evolve. So NISIC feels really that there should be room for flexibility, and that needs to be exercised by clinicians. There's another few things that I just want to mention before I just touch on surrogacy. We would also like to actually get some clarification on whether egg sharing will be permitted in Irish clinics. Also, we would also like clarification on whether a male surviving partner can use embryos via surrogate. And in terms of kind of single embryo transfer, we would defer to the clinician's recommendations on this and agree that this might be decided on an individual basis. And then just in terms of kind of, I suppose, the time limit on storing embryos, we would say that that in some situations can be unnecessarily restrictive for those trying to complete their families, and also obviously those who've obviously had cancer treatment. Then in terms of one final thing before we kind of touch on surrogacy is it was obviously mentioned in terms of having a register under the Children and Family Act in terms of the National Surrogacy and Donor Conception Register, and I think this was mentioned by clinician John Waterstone in the last hearing in February, that we would feel that the proposal whereby a donor-conceived person who applies for a birth certificate would be told by the state that he or she was donor-conceived without ever seeking that information is a dangerous invasion of privacy that needs to be reviewed. And then finally, in terms of surrogacy, and I think obviously it's been mentioned by Deirdre particularly, is that finally in relation to surrogacy, restricting surrogacy to domestic arrangement will effectively rule out surrogacy as an option for many couples, in addition to leaving the children and prospective parents of foreign surrogacy arrangements in legal limbo. Also, in relation to that, the prohibition on providing technical, professional and medical services, save for domestic surrogacy arrangements, will cause unnecessary further distress to many couples in the state, while also potentially leaving clinicians open to fines or criminal action. We appreciate that surrogacy is a very, very complex area. However, the legislative framework will need to reflect the actual realities of surrogacy in Ireland, namely that most of it takes place outside of the country. Okay, and that's obviously, we have a surrogacy support group, and people who come to that group are obviously dealing with surrogacy outside the state, so that is a reality. And we would also like, on behalf of our membership, to ask for clarification on whether parental rights like maternity and paternity leave will extend to the parents of children born via surrogacy. That's one of their key concerns. So that's, I suppose, very briefly, I suppose, the area. So it's really to do with funding, counselling, the register, and also in terms of surrogacy. So what we would obviously, I'd just like to finally say is that NISIC certainly thanks the Joint Committee of Health for the opportunity to obviously submit this statement and to speak at this hearing. And we would ask that due time and consideration be given to review the questions and issues raised in this statement, as they really reflect the people on the ground in terms of who are going through our surrogacy donor conception. And obviously, as a support group, we've been obviously helping those people over the last nearly 30 years. Okay, but we thank you for your time at this meeting.
Thank you very much, Ms. Keegan. And now, could I ask for the opening statement from Ms. Emma O'Reilly, please?
Thank you for the opportunity to speak today. In recent years, since doing my Masters in Psychological Science, I have researched the practice of donor-assisted human reproduction. I found no evidence that it prioritises the best interests of the child. It prioritises adult interests. DC people are the only party who not only do not benefit, but are harmed. Our parentage is a straightforward, unaltered relationship. DC people's parentage is altered at the hands of a third party before they are even conceived. State practices acknowledge the primacy of a child only being removed from kin as a last resort, yet we do not apply this protection to DC children. We ratify the UN Convention on the Rights of the Child, including the right to know and be cared for by our natural parents, yet we do not apply it equally to DC children. We teach our secondary school children that every human being, without exception, comes from one man and one woman. We expect DC children to have no knowledge of this man or woman. We talk of family likenesses, cousins, heritage, ancestry, and we deny DC people this essential part of belonging. We tell them that their genetic family doesn't matter, while we wouldn't be without ours. We give them birth certificates or propose to that differ from ours. We make them very unequal and try to convince them that they are special. This bill will consolidate the disadvantaged position of DC people who will be bound now by law to accept inequality. The longing for a child cannot override the child's need to know the true people from whom they come from. To say that the DC child playing or at school is doing fine is an inaccurate measure. Adoptees of the last century's children would have shown little or no sign of the pain to come. The impact of injustices done in childhood can only be dealt with in adulthood. There are thousands of DC people worldwide who testify to the long-term harm. The Adoption Rights Alliance describes the layers and layers of parallels with adoption practices and those of DAHR. Psychological well-being is bound with a solid sense of self, formed by integrating all the elements of who we are. Our genetic identity provides us with a sense of belonging. It grounds us in space and time. It answers the question, to whom am I related? I am very concerned by the commercial nature of this industry, by the misuse of language and concepts, the dehumanizing rhetoric, the exploitation of students and young Ukrainian and Czech mothers needing cash, recruited on Facebook to breed. I am concerned that in a town called Brno live 350 young Czech women whose biological children live in Ireland with false birth certificates, not allowed to ever know them. I am concerned that an Irish clinic's partner in Ukraine spoke of expanding into new markets in India and send weekly emails to potential clients offering discounts, even cruelly Mother's Day specials. I am concerned that this industry refers to a child's right to their identity as, quote, utterly meaningless, and argue in favour of donor anonymity when we have acknowledged that it is grossly harmful. DAHR does not treat infertility. The infertile person remains sadly infertile. It is simply the outsourcing of a young fertile person to have a child remotely and sign away all contact. There is no mention here of the thousands of children born in Ireland through anonymous parentage who carry now false birth certificates, most of whom are still minors, because this practice really has only flourished in the last 18 years or so, most of whom, according to one clinic, will never be told the truth. We'll be complicit if we don't hold to practice that we know causes profound human suffering. What are we going to say to these future adults? That we didn't know? We do know. Thank you. Thank you for the time.
Sorry? Yeah.
Sorry, that was short because we've split our 5 minutes.
Sure.
Okay.
Yeah. So, finally, your opening statement, Dr. Joanne Rose. Thank you.
Thank you for this opportunity. I'm Dr. Joanna Rose, and I'm conceived from donor conception. I fought for the rights of donor-conceived people. In 2002, I won a High Court test case in Britain and brought an end to donor anonymity. I am aware that you'll be concerned about providing for those adults seeking reproductive interventions. Today, I hope to bring your attention to the other stakeholders, namely those who donated their sperm or eggs, or those who are conceived from reproductive interventions. Firstly, I appeal for the acknowledgement that donors who become genetic parents and those produced from them are stakeholders. And secondly, that they must be given equal or even greater representation than the others, owing to their special vulnerability to the risks yet to be understood. International developments regarding the legal and the social recognition of the rights of these groups has been incremental and has taken decades of hard work and campaigning. Sadly, the best interests of the child in this general scheme are not a proper consideration, apart from ending donor anonymity. Their interests and legal recognition are reduced to welfare taken into consideration as far as is practicable. I would like to reflect on these words and the degradation of legal protection and discrimination accorded to this group. I wonder if it's legal to permit such discriminatory approaches to a particular group of children. The general scheme speaks with confidence about providing counselling and informed consent about the implications and consequences of these practices. I see this as false reassurance because of the dominance of the other two stakeholder groups so far, namely the fertility clinics and the adults who acquire their services. Reproductive technology is a social and a medical experiment, and the adverse impacts and consequences are unravelling over time around the world. I've submitted to the committee a document which provides details of some of the activities of campaigning donor offspring around the world. It's only they that can inform best practice on these things. Mostly, we pay for our own counselling, gene tests, and we find lost relatives, and sometimes live with false birth certificates and absent or misleading medical histories. We have lost ethnicities and ancestors, large numbers of siblings and half-siblings, and all of this confronts us privately in adulthood. There's little understanding of the resulting grief and its disenfranchisement by our families and the communities at large. Ending donor anonymity only ends some of these problems. We should know from bad adoption practice in the past, here in Ireland and elsewhere, that the grief that can be caused by severing natural ties. The difference between adoption and donor conception is that in the case of adoption, the natural ties are intended to be broken for a child before a child is even conceived. Unlike best practice in adoption, donor conception is really about child production and not child protection. With adoption, parents have to pass a vetting process. With donor conception, this is not the case. Why? There are plans mentioned in the AHR bill to create scientific and ethical advisory committees to oversee the practices of AHR. I would like to suggest that the relevant authorities, including the health committees, consult adopted persons groups, along with professionals who understand the long-term impacts of adoption, kinship loss and displacement, and to speak widely with those who already conceive from AHR practices. I would urge the committee and the government to listen carefully to the voices of donor-conceived people. Try not to let this snowball to become the adoption-style scandals of the future. Ideally, donor conception should not be permitted because it involves the intentional severing of genetic kin of future generations as a service or a treatment. Children lose their knowledge and relationships with their natural father or mother or both, and all associated family. This is a huge loss to pre-plan for another generation. But at a minimum, the impact of deliberately severing these natural ties must be minimised by providing long-term state support to donor-conceived people and funding, and to provide them with the help that is needed to find their natural families in the future, and most importantly, when they face these issues as adults. Thank you for your time.
Thank you very much. Ms. Rose. So thank you very much for those opening statements. I'm now going to open the meeting to our members. Deputy Durkan.
Thank you, Chairman.
Thank you.
I welcome our witnesses and I thank them for their contribution this morning, which has been very interesting. And when we discussed this issue previously, we were in the initial stages. You seem to have firmed up your conclusions, or at least you have as a group, in general. In respect of comparisons with the UK, and Professor Madden made reference there, we have a different legal system. Of course, their legal system is different to ours, plus the fact that they have a different constitution, in the sense that they have the one that goes back centuries, the Magna Carta. We don't have that here. We have a written constitution here which is referred to in a different way. Can I ask you, the issues that you raised arising from the various court cases that have taken place in the UK and elsewhere, which we have read about, Mr. Chairman, and I referred to on the last occasion during which we met, on the basis of all that you've seen and heard, you're quite satisfied that the UK system as a model is not suitable for replication here. And would you like to comment further on that, if possible? First question. Do you want to bank the questions, Chairman?
No, that's fine. Professor Madden.
Reply now, absolutely. So thank you very much for your question, Deputy Durkan. Yes, I am satisfied from my knowledge of the court cases, the legislation in the UK, my contacts with academics and commentators and lawyers working in the UK that their legislation is not fit for purpose. It doesn't achieve what it sets out to achieve. It's currently, as I say, being reviewed by the Law Commission there, and yet my point was that we are planning to copy that model in terms of having a transfer of parentage from the surrogate mother and potentially her husband, if she's married, to the intended parents who are required to be genetically related between 6 weeks and 6 months after the child's birth. And I think that's flawed for a lot of reasons. I think having a time constraint on it is flawed because for the first 6 weeks of the child's life, parentage is not certain. If the child is in the custody of the intended parents at that time, they don't have any legal relationship with the child. So when the child is delivered in hospital, usually the optimal situation is that the child would be handed to the intended parents who are genetically related to it. And so will the hospital here then allow the intended parents to leave the hospital with that child, even though they don't have any legal relationship with the child at that time? In some instances in the UK, the child is handed over in the car park. A child baby seat is handed from one car to another because the hospital won't allow the intended parents to leave the hospital with the child, even though that's what all of the parties intended. So for that first 6 week period, if that child needs medical treatment, vaccinations, the parents who are looking after the child and whose custody the child is in, they don't have any legal rights to sign consent forms for that child for the first 6 weeks or later, depending on how long it takes them to get to the court to make a parental order. This is at a time in the child's life, and perhaps Professor Hayes can speak more to this than I can, when they should be I suppose, adjusting to their new lives, to their new family, adjusting to bonding with their child, rather than going through a court procedure that, to my mind, is unnecessary. I fully accept that I suppose that there has to be obviously some judicial oversight and some regulation of this relationship, but my argument would be that this can happen during pregnancy, so that from the time of birth, legal parentage is certain, responsibility for that child is certain, commitment to that child is certain. It can happen during pregnancy, as happens in California, New Hampshire and Greece, for example. So I would say that that's a good model to follow. Also, in relation to the payment issue, I think that the court cases in the UK show that this is a very unsatisfactory model, because it presents judges with a very difficult scenario where they're faced with two different conflicting policy objectives. On the one hand, there's a policy objective in the English legislation which says that you should not pay more than reasonable expenses for surrogacy, and anything more than reasonable expenses is prohibited. So that's a policy that the UK Parliament has set. And on the other hand, of course, all courts have to prioritise the best interests of the child. So faced with a situation where parents have paid perhaps more than vouched expenses, to use that language which is in the bill, where parents have paid more than that, what is the judge to do? Is he supposed to, or she supposed to, adopt the policy that any payment in excess of expenses is bad, and therefore I should not allow these parents to have legal recognition of their relationship with their child? Or do I prioritise the best interests of the child? This is a child being raised by fit and loving parents. Everybody is happy with the relationship and with the establishment of that family unit, the surrogate mother, the intended parents. There is no aspersions cast on these intended parents by virtue of the fact of them going through surrogacy. That in itself is not a negative connotation. So the judge will always go with the best interests of the child, as courts are always obliged to do. And that means that the judge is ignoring the other policy, which is against commercialisation or against paid surrogacy. So that brings the whole legislation into disrepute, in my view, because you're saying the law says you shall not pay more than reasonable expenses, but when it comes to it, the courts will always ignore that in favour of the best interests of the child, as they should and as they must. So why would we insist on putting something into the legislation that's going to be ineffective, going to be ignored in practice, and doesn't serve any purpose?
Thank you. Chairman, in your opinion, is it possible to craft a bill in such a way as to circumnavigate the legal difficulties that have arisen in other jurisdictions, and at the same time have due regard for the fundamental rights of the child and for human rights legislation nationally and internationally?
Yes, I do think that it is possible, and I have in my submission, the longer submission that I sent in a number of months ago, I have examples from California and New Hampshire, for example. I particularly like the example in New Hampshire because it involves judicial pre-authorization of the surrogacy arrangement, so that there's evaluations, there's screening, there's counselling of all of the parties prior to any medical procedure taking place, to make sure that everybody knows what they're about, everybody knows what the object of this medical procedure is, everybody knows that it is intended that the intended parents of the child will receive custody. There will be home studies of the surrogate, the intending mother, the intending father. There's age requirements, for example. There's requirements in relation to genetic counselling. There's residency requirements. So at the initial hearing, the judge will validate the surrogacy agreement after meeting with the parties, reviewing the terms and agreements of the arrangement, verifying that all the required counselling and evaluations have occurred, and finally determining that everything is ultimately in the best interests of the resulting child. So that process takes place at an earlier stage, so before the impregnation or before the embryo transfer, or depending on the state, it can happen during the pregnancy. The birth mother has the right to take all healthcare decisions regarding the pregnancy and regarding the fetus. And once parental rights are transferred to the intending parents, they have a duty to support the child from the moment of birth. The child born under surrogacy is always considered the legitimate child of the intending parents. So I think that is a very good model.
Can I
Professor Milne. Yes, Deputy Durkan.
Chairman, yeah. Again, the question of anonymity, and we've come across a number of cases in the past that we've read about. From your point of view, from a legal perspective, and what can I ask from a medical perspective as well, the implications of anonymity or precise donor identification?
I suppose, well, my view is that there should not be anonymity. My view is that the rights and interests of children require identification of their biological parents, should they wish it.
Suppose they don't wish it.
But then I don't think that information should be forced on them. I suppose the issue that arises in those instances is if the children are not informed by their parents that they have been born through donor conception, then they don't know that they can access that information. And therefore they never seek it, so they're never told by the state or anybody else. Obviously, I suppose the public awareness and education and support that should be given to intended parents through surrogacy or through donor conceived or to DHR or whatever procedure that is being used, egg donation, embryo donation, I think there should be encouragement, counselling, support for parents in that instance to encourage them to tell their parents, to tell their children at the earliest possible opportunity that they have been conceived in this way, and therefore it never comes as a shock to them, and they grow up knowing the circumstances of their birth and that they can access information in relation to the donor when the law considers it appropriate. So I would be fully supportive of identification of donors.
From a medical point of view, perhaps?
Thank you. I'm not actually speaking from a medical point of view, but from the psychological development and the early child development attachment perspective. The research certainly indicates that openness about provenance is positive for children, and therefore I would be in support and have been in support of identification for the child. I do think the genetic link can be very important to children, and it does seem from research that there is available that in cases, say for instance, of surrogacy, adolescents, because we're still in the very early stages of understanding the trajectory across the lifespan, but in early adolescence, children or young adults have a kind of an indifference, really, a curiosity, but not a great kind of urge to be seeking out further information. But I think the observations made here on the right are valid observations. The sense of belonging and the sense of being part of something as you're getting older does appear to be the case, and where openness has been the norm, it makes that much easier for everybody, and there's no secrecy and there's no apparent deception. And whilst I do appreciate that parents sometimes choose not to tell their children out of a sense of protection and so forth, not necessarily deceit, it is nonetheless a withholding of information that I think children would have a right to. So therefore I would be very much in support of it and feel that the research supports it also.
Can I speak to
Ms.
that?
Rose, yeah.
Thank you, Dr. Rose. Well, in the UK, there's an idea that if you encourage parents to tell their children that that's enough, but the vast majority of people who are donor conceived aren't told. So I think it's very, very important, if you're going to proceed with these practices, to make sure that in law the state isn't complicit in children being misinformed about their own medical history. Norell's law that was developed in Victoria, Australia, was as a result of somebody dying from having the wrong medical history. And there were 8 children in 8 different families who were predisposed to the same medical history, but they weren't informed necessarily that they were donor conceived. So they have something called a time to tell campaign in Victoria. So if you're going to model your legislation on anything, I would certainly not model it on the UK model. I would go for at least the Victoria Norell's law model. Otherwise, you know, my court case established that we have a human right under Article 8 to know our identities is irrelevant if you don't know that your human right is being deprived because you have a misleading birth certificate. And then with all these gene tests that are available from Ancestry to FTDNA, I'm on all these support groups where people are finding out in their 60s that they are donor conceived and that they've been lied to and misled all their lives, and that anger that people invariably feel, not only towards their own parents, but also towards a system that was complicit in that type of deception, is intense. So I think it's absolutely vital, if you're going to proceed with these things, that you legislate for at least transparency about this taking place for the next generation, so they know they cannot be lied to and the state is not complicit in being misled.
Last question.
And just, if I can...
Yes, Mr. Freeland.
Just also to say that there are children who know from the very beginning, Alana Newman being one, and it still doesn't change it. So while it's better not to withhold the truth, there are plenty of donor-conceived people who've known from the very beginning and their parents were completely open, but they still reach the stage that we all reach of wanting to know, well, who am I? And feeling different. And there's, from talking to adoptees and donor-conceived people, I see this common thread of people using the word different. I just felt different or displaced. I mean, my neighbour is one of these, as she calls it, late discovery adoptees of Ireland from the illegal system. And at age 50, she found out, and she, you know, never knew this mother, and through DNA was able to find her biological mother. And she says that it brings everything, it makes everything make sense, that here's a woman who she laughs like, who she has so many similarities with, and this connection that she never had in the family that she grew up. And it's not to say that there aren't very good experiences and loving people, but you have to come back to the fundamental starting question of when is it right to separate a child from their genetic family, and that's the starting point, not further down the line of saying how can we make this better. We have to ask when is it right, and we know in all our other practices it's never right unless it's for their protection, and this isn't for their protection. It's not even a medical procedure. It's using a medical tool, which is IVF, which is a fabulous medical tool that means that you can now fertilize outside the body, but it's taking that tool which has been used for AHR and taking the concept of distance, that you now have a man and a woman, and they can be anywhere in the world, but if they can be used to fertilize a client. And I think that's the important part, that the distance that makes it all seem very clinical and very sanitized, and we don't see it down the road. But what these clinics are doing is finding the greatest source of fertile young people. And that's students. So that's 19, 20, 21-year-olds. That's our children. So if they were going down to Trinity and UCD and saying to their client, hold on now, you sit there while I go down and find somebody who's going to breed. And they recruit these massive young students. And students our students, that they're young, and money, and this comes back to the point of compensation. You can regulate as much as you want for compensation. Compensation is still incentive, it's still money. And if you're a student, I know in Denmark men get €200. That's a lot of money if you're a student, even if it's just drinking money. And similarly for women, women get paid, I think about £1,000 it is in England, roughly €1,000. If you're in the Czech Republic or Ukraine, that's a huge incentive. And once you have money in it, it becomes business. So clinics are doing wonderful things with IVF and with technology and helping. But when helping somebody else is tightly connected with your financial gain, then it's a business.
Can I, last question, Chairman?
Yes,
can I ask, given the earning of childless couples, to have a child, and we recognise what has already been said in relation to the costs associated, we have to take that into account, to the effect that it can't be an endless chain of increasing costs, because we can't allow that to happen. Can I ask you, from a medical point of view, a legal point of view, an ethical point of view, are you satisfied that it is possible to construct a bill in such a way as to meet the various criteria that you have in mind and to which you've already referred to? Are there contradictions there where they cannot be reconciled? And if so, to what extent do you see them as being a major impediment in the construction of the legislation? Last question.
Ms. Rose.
Thank you. To be honest with you, I think in terms of if you're going to have laws which have a primary responsibility to the child, the best interest of the child, I don't think you can intentionally separate children from their genetic parents by design and say that that's in a child's best interest, because it's not. Having said that, I see it as I have to argue for damage limitation and raise your awareness about, if you're going to proceed with this, how you're going to do it to avoid as much damage as possible. I mean, things like sister clinics being abroad and facilitating conception, state funding to facilitate conception abroad, which is with anonymous donor conception, which does everything that you then say is not in the realms of recognised human rights, just has to stop. And that happens in England all the time. There's loopholes. Having committees and that are dominated by the infertility service providers and those that receive those services just has to stop. If you're going to try and even think about appropriately protecting the best interests of the child and those people targeted to be donors, you have to reframe this practice and have a more appropriate representation of those stakeholders. And in this bill, I'm desperately unhappy about the dominance of those other groups. I think the wording of the bill, where the welfare of the child is taken into consideration where practicable. You have that term for the prospective children to be conceived from reproductive technology, but on page 60, head 22.7, they talk about a future child who might be found to be infertile, and they refer then to it being in the best interest of the child to remove their gametes without their will or consent necessarily, so that they can be genetic parents. So genetic continuity for one group of children is seen as important, and their best interest is a term that's used and applied legally. But yet you have another group of children where it's welfare taken into consideration where practicable, and their genetic discontinuity is not even a consideration. That is so clearly discriminatory that, you know, the emperor has no clothes. Can anybody see that? That is clear discrimination.
Thank you, Ms. Rose. Oh, sorry, excuse me, Professor Hayes.
I'd just like to come in on that, and I mean, I think this is a point that I was alluding to across the general references that I made in my opening statement, that I think the language of the bill needs to be reconsidered to take account of the child across the age range, not just at the point of arrival, at the point of birth, but beyond that. And that does have implications, as you say. It has implications for support support services, for advice services. It has awareness-raising implications for society as a whole. I think the reality is there, and therefore we need to be careful to counterbalance the previous overly powerful role of the clinic and the parent and the state. So I think it can be done. I think the language, we're actually, because we're coming to this so late, we actually have an opportunity to develop a model legislation where we really take account of what the research is saying. And I mean, I think there's good example here, and I've talked about the need to actually listen to the voices of people who've gone through this process. I think we've a lot to learn from those voices. I think we take that on board then in terms of the supports, and it feeds to some extent into the observations that were made here. But the bill itself, the language of the bill itself, is not, in my view, sufficiently robust in terms of both, as I mentioned, the child across the age range, but also the state support for the parents of that child to guide the parents on the importance of openness and transparency, but also to support the parents and the children dyad as they progress through life. And there's no doubt about it, there will be points at which tensions can arise and information can create difficulties and problems. And if we're thinking about that at this stage, the likelihood is that those tensions can be handled rather better than if we're not thinking about them at all.
Thank you very much. Professor Madden.
Thank you. You asked the question, I think, Deputy, as to whether or not, from a legal perspective, I suppose, whether this can be achieved. And certainly, like Professor Hayes, I certainly welcome, as a member of the Commission on Assisted Reproduction, I certainly welcome the point that we're now at. I've been involved in this area for 30 years as a researcher and a writer and as an academic. I have a master's and a PhD in the law relating to assisted reproduction. So I strongly welcome that we're at this stage now, finally, that we're at least talking about introducing legislation. And I welcome the fact that this proposed bill has been informed by the recommendations of the Commission on Assisted Reproduction, because that was a lengthy process. It took 4 years, I think, with multidisciplinary group, with expertise, with submissions and so on, and it was a very worthwhile exercise. So I particularly welcome that the bill has been informed by that in terms of establishing a regulatory authority, independent inspections of clinics, national standards, international best practice. All of those things are crucial. And I think the bill broadly achieves the aims of clarity and certainty in relation to IVF and treatments with donor gametes. But in my opinion, there is still a lot of room for improvement in relation to the current bill. I think there are revisions that are necessary in terms of wording and language and terminology and all of the things that the others have mentioned today, and which I've also expanded on in my submission. But in my opinion, the major flaw of this bill is in relation to surrogacy, and I think that this flaw will result in continued travel for Irish people to go abroad for surrogacy to other jurisdictions, because they will be unable to avail of the very limited mechanism offered by this bill. And I think the lack of clarity in respect of those children born in those circumstances is contrary to the best interests and rights of those children, and I would certainly urge that that part of the bill be rectified at the very least.
Thank you.
Thank you, Deputy Durkan and Professor Madden. Now, Senator Ronan Mullen.
Oh, right. Okay. Thank you very much, Kylie. I'm happy to keep listening. I have some questions, but I'm continuing to formulate them in the light of what I'm hearing from the various participants.
We're going to be open
about when you want as well.
You can come in and out as you.
Okay.
Within reason, of course.
All right. Okay. Yeah. Well, could I maybe just start then by saying, just to try and to thank everybody for being here and for their presentations, and indeed their answers to the questions so far. It's probably not unjust, is it, to characterise our two guests on the left as being fundamentally opposed to much of what's in this, because they see it as fundamentally in breach of a child's rights in principle, because you are separating a child from genetic connection with at least one of his or her genetic parents. And from listening to you, I just sense that no amount of tweaking really undoes that injustice. But I don't want to put words in your mouth. I'm just trying to clarify what I understand your position broadly to be. Now, I didn't hear you, but having read you, am I fair in saying that you believe that the benefit outweighs, which is the benefit for infertile individuals or couples who want, and that our two speakers in the middle are broadly saying we have to go with it, and therefore it's a question of tweaking it as much as possible to take account of your concerns, but that broadly speaking you are in line with the idea that this stuff is going on already, therefore it needs to be allowed to go on as opposed to being publicly discouraged. Am I in the ballpark in terms of understanding your positions fairly there?
Which one of us are you addressing?
Well,
Can I just say that I don't think the issue is tweak. No. I actually think there's considerable work needs to be done to actually address the reality of the contemporary AHR world in Ireland. And I think some of the issues that have been raised are really critical issues that need to be considered, and the opportunity is here, I think, to consider them. It's beyond tweaking. I think there's a power issue here that you have to take into account, and I think that the child is really the central element that we need to be considering, and historically that hasn't been the case, and there's lots of reasons why it hasn't been the case, but I think we have an opportunity now. But it is, I think, beyond tweaking. There are issues of language, and there are issues of kind of directionality of points and commitments that are long-term, not short-term.
But are you generally persuaded then that by what our two friends on the left are saying, that there's fundamental breach of child's welfare once this happens at all?
I don't see that necessarily as the case. I mean, I think there are very complicated situations that can definitely be resolved by assisted human reproduction. There are needs met, which I think can be legitimised, certainly. So I wouldn't hold the particularly strong view that you hold in relation to the genetic origin being predominant in that sense.
Thank you.
Thank you. I think there's an inherent flaw that you're right in picking up on. In one instance, we're asking for state funding to try and help people become as much as possible a genetic parent, and it's referred to as a huge blow if intending parents have to use a donor. So, and again, back to head 22.7, if a future child might become infertile, there's an effort to help those children become genetic parents with state funding. You have another group of people, and there's a complete disregard for their genetic kinship, which is literally severed as a means to an end. That's discrimination. One group of people's genetic continuity is valued and advanced with state funding at the expense of the other. There's no way that that's not the case. So if genetic continuity doesn't matter for one group, then maybe it doesn't matter for the other. If it matters for one group, then it should matter for the other. So what happens is that then people say, well, it's happening anyway, you've got to get modern, you've got to get liberal, and we've got to make laws in place to limit the kind of damage that can take place. So the laws and the ethics are made on the hoof.
But are you, if I may just interject, are you conflating two issues there, if I may ask, though? Because if I understand it correctly, and I have ethical issues with it myself, but if I understand it correctly, nobody is being deprived of the opportunity to pass on their genes. The question is whether you're to be allowed to know the person whose genes have been passed on to you. Aren't they two different things? If what you're talking about is a provision that will allow genetic intervention, so as to ensure that a future child may be able to pass on his or her genes, that's a different right to the right to know whose genes you have.
Yeah, entirely different. And to meet a genetic parent when you're 18 or over 18, there's a lot of, the implication is that all we want is information. And obviously, as a group, you know, some people won't want anything, just like some women won't want the right to vote. You know, but as a group, we need to be given the whole range of rights, and we can access which ones we choose. And actually, knowing a genetic parent at 18 and then finding out that you've got maybe 20, 30, maybe 200 half-siblings in different families, maybe in different countries across the world, hands a huge burden onto that next generation to deal with in adulthood. And that's the kind of discrimination I'm talking about, where there is this absolute empathy for people who want to become genetic parents or become genetic parents, and they're represented in the committees, they're represented in so many ways. They're so powerful. But yet for that next generation, the real complex issues that they're handed as a means to an end for another group, for another generation, is not properly understood, and we're not appropriately protected or represented in these kind of environments.
Sorry, just to go on the same subject of, I don't see any question of assessing the risk assessment or harm. Like I know Professor Hayes would know from psychology, you can't even interview a child or do any experiment on a child, even if it's just a verbal interaction or a questionnaire, without really seriously scrutinising the ethical implications of any harm. And here we have an experiment, which it really was an experiment, that involves children. And I don't see anywhere any assessment of harm. I see us, as you were saying, that dealing with what is here now, but what is here now may actually be harmful. The train has come in, and we're not looking at, we're saying, okay, let's legislate for it now so it can carry on its journey. And we're not seriously scrutinising what's on board that train and where it came from. And we know the origins. The origins, I think, were told a very amusing anecdote on RTE's Going It Alone. It was a woman, a fertility counsellor, not a doctor or a scientist, who brought in sperm from, I think, England, and brought it in through customs in Dublin Port and registered it as cattle sperm because there was no other category for it. And this is meant to be amusing, that this is just sperm, but I'm just one sperm and one egg. You know, we all are. We're all donated, and you can't separate that. So to say that we legislate now, I mean, I understand that we have to grasp what is here now, but before that, we need to really examine all the various elements, including the financial element of it, and really specifically the financial element of it, and taking away languages, as Professor Hayes was saying. I mean, calling somebody a donor, that's a parent. You know, you can't write about donors and eggs and gametes as if they are just bits of tissue. These are the pieces that make a human being. They're not donating blood, they're not just a tissue. They are the only elements in the nucleus of those two cells is me. And I don't want to be called a gamete and a property. And you see it in the brochures of the clinics, the words property. And if I'm going in to buy an egg from a woman down the road, Ukraine, but say from a woman down the road, I sign that this egg is now, and the language used is, this is my property. Like, that's a human being that has been transferred as a commodity. And that was our problem in Ireland with the adoptions. We talked about how they were commodified, and we're doing the same thing, and we're saying it's okay. And even all our talk today is about this commodity. This is a human life, as if there's a child sitting there in front of you, and you have to look them in the eyes and say, this is you, and this is your life. So no matter how much we legislate with using this language, none of it is acknowledging the harm and the human emotional impact of all of this. And identity isn't just a bit of paper, it's a very fragile thing that can be very easily damaged. You know, so you do have to go back to the beginning, I'm afraid, and look at the practice, look at the money that's involved. I mean, we donate a kidney and an egg, or not an egg, we donate a kidney and blood, and for donating a kidney there can be expenses, but you're not compensated for that. And for a reason, because then it takes out the incentive. And we have all of these international conventions, the EU Charter of Fundamental Rights, that forbids financial gain from the sale of body parts. So how does that fit in? And you have the Council of Europe's Convention on Human Rights and Biomedicine that really clearly states that biomedicine brings great hope but poses a huge threat. And we need to, I don't see that here, acknowledging any element of that. And again, it forbids the sale of financial gain or advantage.
Thank you very much, Ms. O'Reilly.
I'm just conscious that our two friends on the right, but you're the chair, but they may want to contribute as well. I have other questions, but I'm happy to wait, as I said.
Yeah, okay, thank you.
I suppose what I would say is that obviously we're here to represent the patient voice, so obviously we've done that over 30 years. And the co-founder, Helen Brown, who was part of the assisted human, she obviously was on a journey to have a child, and unfortunately she wasn't able to have one. And I suppose we're dealing with the situation as is. So people who come to our meetings basically are in a situation where they're trying to consider different options and see how they actually deal with them. And obviously as an organisation, we obviously did the first, as I said before, family conversations event, which is to do with obviously starting the conversation with their children. So obviously we as a very small organisation that has very little funding and basically just relies basically on volunteer, and we've only got one person who works part-time. So we're trying to do the best we can in the situation to provide the support that we can. I mean, I do take on board everything everybody has said here, and I'm not claiming to be an expert in terms of obviously Dr. Rose, and obviously you've got your own viewpoint, and obviously there's also the psychological and the legal. But what I would ask maybe is that if we can learn anything from the adoption process, because obviously there was like commoditisation of adoption and so on like a number of decades ago, is there anything that we can learn from that process in terms of when we're actually putting down the legislation? In other words, like, do you feel that the process both in Ireland and England is dealt with in an appropriate way when a child is adopted in terms of them coming to terms with that situation? Like, I'm just trying to understand, is there something that we can do around, because I guess my feeling about all of this, and I take on board everything that's said, is that there's a huge emotional element regardless of whether it's donor conception or whether it's adoption. So even if a couple do adopt a child or did adopt a child 10 years ago, maybe they're also dealing potentially with these issues as the child goes up. So is there anything that we can learn from that can be...
The Lions have said to us very clearly it needs to be...
Excuse me.
I'm sorry.
Rather than having a conversation across the witnesses, we might have a conversation across the floor, if you don't mind.
Sorry.
Yeah. So I'm just going to move on. We can come back to those issues. Could I ask you, Professor Madden, just to outline to the committee what the present situation in relation to surrogacy in Ireland is, what the bill proposes, and what you feel should be the future?
Well, I suppose the situation in relation to surrogacy at the moment in Ireland is that we don't have any legislation dealing with it, as you know. So it's a complete legal limbo, I suppose, for couples. Irish clinics don't generally provide surrogacy services, as I understand it. There were one or two cases in the past, one of which ended up in the Supreme Court in the MR versus Antord Clorahor case before the Supreme Court a couple of years ago, which was about a birth registration issue. Most of the couples who seek surrogacy therefore go abroad in order to avail of that service, and then the issue arises for them as to how they can regularise their legal relationship with their child when they bring it back into this jurisdiction. Some countries are easier, I suppose, in that respect than others. Couples that I've spoken to in Ireland who've gone to the United States, for example, to California, find it fairly easy to avail of the legal process there because they're regarded as and registered as the legal parents of the child in the United States. They go to an Irish embassy, they get travel documentation, an Irish passport, and they can bring the child back here. So for them, the process is fairly easy. For others who go to other parts of the world, India, at least until relatively recently, India, the Ukraine, Mexico, Nepal, and places like that, the process can be a little bit more difficult because there can be what we would call a conflict of laws problem where, for example, the Irish law takes the view that the woman who gives birth to the child is the legal mother of the child and therefore has to be registered, whereas in some jurisdictions where surrogacy is allowed, the birth mother is not regarded as the legal mother, it's the intended mother is regarded as the legal mother. So you have two different conflicting legal frameworks, and the problem then arises as to what happens in that clash. So who is the legal mother? And there have been examples in English case law, for example, where children have been born in other jurisdictions where that conflict of laws problem has arisen, where, for example, in the Ukraine, the intended parents would be regarded as the legal parents, but in the UK, the surrogate mother would be regarded as the legal parent. And there have been difficulties in that context in terms of getting travel documentation and passports and bringing the child back into the jurisdiction and going through a court procedure to regularise that situation. And that's extremely stressful and anxiety-ridden time, I suppose, for parents, and probably not, I would say, without the expertise of Professor Hayes, not in the best interests of that child. So that's the situation we're in at the moment. The bill is proposing a situation where there would be pre-authorisation by the regulatory authority in Ireland of the surrogacy arrangement, but the legal transfer of parentage would not take place until between 6 weeks and 6 months after the child's birth. And that goes back to the point I was making earlier about that not being in the child's best interest, because from my perspective, that transfer should take place before the child is born so that there is legal certainty from the moment of birth, because that child might need medical intervention, might need surgery. the intended parents who are looking after that child won't be able to sign a consent form. So I think the bill should certainly address those issues and also address the issue of bringing children back into the jurisdiction who are born to Irish parents abroad and should regularise their legal relationship.
When you say born to Irish parents, genetic parents?
Yes.
Yeah, okay.
Yes.
Thank you. Ms Rose.
I think in terms of surrogacy, it's fascinating the way there's been quite a lot of emphasis on the importance of the people being the intended parents who are genetic parents. All of a sudden that's important, but for the donor offspring it doesn't really matter. Very interesting change in terms and emphasis. And often in the case of surrogacy where you have IVF, the surrogate mother can by accident become the genetic parent. So I think you need to legislate to have testing of that child to check whether indeed that child was conceived from surrogacy after all of a donor egg. But in terms of that, like when there's discussion about the best interests of the child, I'm fascinated to hear that when we talk about the stress for the child, things like separation from that mother that carried that child hasn't yet been discussed. That when we look at adoption and, for example, the information we have from Nancy Verre in the primal wound, the significance of being removed from the mother that's the only person you've known. When you gestate, you're having the foods that your mother eats, the sounds, the music they're listening to. You know, when a child is born, I know from my own experience, the only person that child really wants is the mother that gave birth to them. So I think it provides an example of the sheer lack of understanding about the types of impacts and emotional impacts for those children produced, that there is literally no discussion yet here at the table about the stress to a child of being separated at birth, in the car park, or whatever it is legally, at all through surrogacy, and that fragmentation of their of their sense of motherhood.
Thank you. Thank you, Ms Rose. Yes, Professor.
Could I perhaps just come back on that point? And I'm not claiming to be an expert in this area, but of the studies that I have read from Susan Gollenbuck and others in the UK who have done extensive work in relation to in following up, I suppose, in longitudinal studies of children born through surrogacy and donor-assisted reproduction, the surrogate mothers, the intended parents, they have not reported any negative outcomes in terms of the welfare of children born through either donor conception or through surrogacy.
Sorry, I'll bring you back in a few minutes. Just one more question before I go to Deputy O'Reilly. Just to clarify the situation in Ireland at the moment, the most common form of assisted human reproduction is IVF, I presume.
Yes.
Surrogacy, in number terms, would be very small in compared to the numbers who are conceived by IVF, I presume.
Yes, and that's also because clinics traditionally here don't provide it. Yes.
So IVF from with genetic material from both parents is the most common form of assisted reproduction in
Yes.
Ireland. And are there any legal deficiencies in relation to that in Ireland at the moment?
Well, I suppose in terms of some of the comments that I've made in my submission, there are some wording issues. Really, I suppose, to go back to the word tweaking that Senator Mullen mentioned, I think there are some wording issues that would help to improve the bill in terms of things like the welfare of the child. There are some issues in relation to consent, I think, that need to be looked at again. There are issues in relation to storage. There are issues in relation to posthumous reproduction and so on. But I think the general scheme of the bill in respect of IVF is appropriate.
Okay, thank you. Now I'm going to bring in Deputy Louise O'Reilly.
Thanks very much, Chair, and good morning, and thanks to you all for coming in. I have a few questions, and I think they're kind of directed at individuals, but obviously anyone is free to respond if they wish. Dr. Madden, you refer to the surrogacy frameworks in other jurisdictions, and I note that you're critical of the British system and our apparent eagerness to adopt that. And I've said it before, if they're doing something wrong across the water, it seems to be the first thing that we want to do. So I'm just wondering if there are frameworks out there, if there are countries who have got it right, who are being fair to those couples who need the help, also fair to the children. And just to be clear, the Dr. Rose spoke about the potential damage to children, but you're saying, Dr. Madden, that there isn't, or sorry, to mothers, but you're saying that the research that you've consulted doesn't bear that out. Okay, yeah, I just wanted to check that. Also, you referenced the avoidance of potential exploitation. Now, that is something that we have to concern ourselves with, because that is a very, very serious issue. It's one I raised actually when this bill was considered first. How can this be achieved? I mean, can it be achieved via a legal agreement? Can it be achieved? Is it optimal to put that into the legislation? Would it be preferable to maybe produce guidelines that might ensure? See, the difficulty is when you go outside of this jurisdiction, and as you have said, you're trying to marry up the two laws, and but not we clearly as a committee nor as legislators, we don't want to do something that is going to somehow inadvertently lead to exploitation. So we need to have those safeguards in place, and I'd just be very interested in your view. And it might be that we don't have the time, because I say it might be a bit complicated. So if that's the case, you could send us on some of the research as well if we don't have time to go fully into it. Okay. Ms. Keegan, you referred to the upper age limit of 47 as being problematic, and I'm just wondering if you had an upper age limit in mind. Should there be one? Should there not be one? I'm just interested in hearing your view. You also say that most surrogacy takes place abroad. Are there any figures on that? Now, I know it's not a very highly regulated area, but if you can hold your answer to it, and I think we'll just take all the questions together if that's okay. And I'm just wondering if we have any idea the percentage-wise, what way it breaks down, just for our own information. And Dr. Hayes, and also Ms. Keegan, there are two conflicting views in your submissions. Okay, so Dr. Hayes, you say that a birth by surrogacy certificate should be issued, and Ms. Keegan, you say that you shouldn't be giving people information that they don't necessarily need or will want to look for. So I wonder if I could ask both of you to comment on the other person's view, maybe if we can try and just get ascertain some sort of what would be the best arrangement, because it is kind of tricky. And I was thinking about it. In one respect, you're right. It is information that people haven't looked for. But then, on the other hand, it might be information that they have a right to. So it's how to marry that up. And let me see now. Dr. Rose, you spoke about your intention you're here to do some damage limitation. And I'm just wondering, we got a submission from the Iona Institute, and it's co-authored by Joanna Rose. You're the same person that did that. Okay, so in that submission, it raises questions about the family structure. Now, I support fully the rights of same-sex couples to adopt and to rear children. But I'm just wondering, in terms of the damage limitation, would you see the exclusion of same-sex couples as being part of that damage limitation exercise you were here to do? Do you have a view on that? Because I think that would be very, very interesting for us to know. Miss O'Reilly, you refer to in your submission a TV3 documentary and references to the industry. I'm just wondering, by way of academic research, now I know that you studied, it's in your bio, you studied medicine for 2 years, but you're obviously not a doctor, but I'm just wondering if you would have any academic evidence or anything that might be, you refer to industry adverts and a TV3 documentary, but just by way of empirical evidence or academic evidence to back up your assertions, if you could just even provide us with some of them here and maybe send us the list afterwards. So, because obviously we have a huge amount of reading and consideration and discussion that we have to do on this legislation, Chair, and I think there's no going to be no easy way to do it other than to just get right in and read all of the available academic research and expert evidence that might be out there. And I think I have a few other questions, but I can hold them till after.
Okay, thank you very much. So Professor Madden first, and then maybe Ms. Keegan, and then Ms. Rose.
Thank you very much.
And Professor Hayes, of course.
Thank you very much, Deputy O'Reilly, for those questions. So the first question you had for me was in relation to, I suppose, the issue that I raised about us copying flawed English legislation, which is, I suppose, not unknown in this jurisdiction. I suppose my view would be that there are certainly better frameworks out there, and some of which I have referred to in my submission. California and New Hampshire being those that are most easily accessible in terms of language, but also in terms of the clarity that they achieve. The Commission, if I can just refer back to the Commission on Assisted Reproduction, recommended that the child born through surrogacy should be presumed to be that of the intended parents. And I suppose the frameworks that I'm referring to as better frameworks would adopt that model. So they would recognise the parentage of the intended parents before birth, as I mentioned earlier, to make sure that from the moment of birth there is no ambiguity, there is no legal uncertainty. And I think that in that process of recognising legal parentage of intended parents, that can be done by a judicial process, a judicial process during the pregnancy, to make sure that, or before the pregnancy commences, even better, I suppose, to make sure that everybody's appropriately screened and counselled, everybody avails of independent legal advice so that they know the relationship that they're going to engage in, and then transfer of parentage occurs at that earlier time. So that would be, in my view, a much better outcome for the child.
And just with regard to the two areas that you, for ease of reference in the English language, probably, just, and we'll have access to other information. But in California and New Hampshire, it's before birth that takes place.
Yes.
And I would be concerned that a judicial process like that would be overly burdensome in terms of money. Just access to the law is expensive. And you're talking about a very time-limited sort of process, if it is to be done. So in that regard, it would nearly be, and I'm only just teasing this out, but it would nearly be better if it was done before conception.
Yeah,
because
there are lots of reasons.
You wouldn't have a ticking clock, if you know what I mean. You wouldn't have that
I suppose
kind of
there are
time
lots
pressure.
of reasons why it might be preferable for it to be done prior to conception, so that to make sure that the judge, whoever is scrutinising the process, can be satisfied that the woman who is going to undertake this as the surrogate mother has been appropriately screened. She knows what the process involves. She knows that she will be relinquishing the child after birth, and to make sure that the judge is satisfied that all the statutory criteria have been met before the pregnancy already is in existence, so that if there is any doubt, if there is any concern about her appropriateness to undertake this role, then obviously it wouldn't be...
There's time then.
There's time.
Yeah.
In terms of the cost, I suppose I would say that, the bill that we're talking about today also involves a judicial transfer of parentage, so there's still a cost. It's just a matter of timing. You either do it before conception, before birth, or after birth. So there still is that judicial transfer, so that the cost will remain the same. It doesn't have to be necessarily complicated litigation. It's a pretty straightforward court application that shouldn't necessarily cost a lot of money, but access to courts is certainly not cheap. So that's in relation to your first question. The second question was in relation to the question of harm. And as I said, I suppose I prefaced that by saying that I don't claim to be an expert in this area. I read the studies and the research from a legal perspective. So, and perhaps Professor Hayes might be best placed to answer those questions. But from my understanding of the research that I have read, there is no demonstrated evidence of harm to children born as a result of assisted reproduction or surrogacy from the studies that I have read. Now, I would also have to say, of course, that the studies to date are of, I suppose, if you look at surrogacy, for example, the children in those studies are still probably in adolescence, and we don't know whether those studies will show the same effects when those children reach adulthood and into later life. So because of the fact that those studies are longitudinal studies, they've started when the children were very young and they're now in adolescence, they don't demonstrate any negative effects thus far. But we still have to continue, and I would echo Professor Hayes' point about the necessity to have ongoing research in longitudinal studies to make absolutely sure that that remains the case. And the last point that you mentioned was in relation to exploitation, and I think the issues that arise in relation to exploitation, which we are rightly concerned about, is the potential for vulnerable women in poorer socioeconomic climates being used and exploited in this way. I suppose there's two answers to that. The first is, why do people go abroad to these jurisdictions to avail of surrogacy abroad in the first place? It's because the legal regimes there are more favourable to them. They give them clearer legal rights to their children, and that's probably the primary reason that they go abroad, because they don't want to have to go through the stress of litigation in their own jurisdiction. So I think in light of that, I think the preferable approach to that, to avoid exploitation, would be to put surrogacy on a proper footing here. So then there's no incentive for people to go abroad. If you have it regulated properly here with proper safeguards and screening and counselling and informed consent and all of those things, then there would be no need for Irish people to go abroad. Obviously, the potential for exploitation will remain, and I know that the Hague Convention, for example, is currently looking at the possibility of putting in place an international convention to reduce the possibility of exploitation in places like India, Nepal and Mexico and so on. But we're not at that stage of having an international convention yet, but that's possibly the only way that on a global scale, we might be able to avoid the exploitation in the future. But as I say, in terms of why do people go abroad, it's because they want the security of knowing that they will be the legal parents of the child if they go through this process.
I think that's a very important point.
So if we put that here, then people won't need to go abroad.
They wouldn't need to, because they're travelling for legal certainty. They're not. I know they're not travelling for exploitation. They're travelling for legal certainty.
So as I said in my submission, that if the bill is retained in its current form, my concern is that people will still travel abroad for surrogacy. So therefore, we're not actually tackling the issue of exploitation. We're just trying to make sure it doesn't happen here.
Okay, that's good. Thank you.
Ms. Keegan.
Thank you, Deputy O'Reilly, for the questions. In terms of one of the questions you pose is do we have numbers in terms of surrogacy? Well, I don't have numbers in terms of surrogacy. I know obviously we have a surrogacy group that's quite active within NISIC. I think in terms of, I don't think there are any numbers available unless somebody else has information. What I would probably say is that there are specific groups who are obviously campaigning and dealing with surrogacy in the Republic of Ireland, and they would probably be better placed in terms of obviously giving maybe a patient voice in terms of surrogacy and their particular issues. I obviously can represent some of their issues, but they might be better placed to give some idea of the numbers. Okay, so there's obviously a legal thing.
I was referencing it's in your submission that your belief is that the majority of surrogacy takes place abroad, so that's your experience.
So basically, obviously, when we have surrogacy groups, so people are coming who are obviously considering surrogacy or going down the road, the bulk of that, or basically all of that, is basically foreign-based. Okay, I know there has been certain situations where there has been obviously domestic surrogacy, but I think that's probably very rare over the last 10 or 20 years. But in terms of numbers, I don't know if anybody else does, but I don't know.
I don't think so.
In terms of the age limit, what I would probably say is obviously we're not clinicians, we're just representing the patient voice, and what we would probably say is that we would defer to what the clinicians say. We would say that I have looked at some of I suppose across the countries in Europe, and I think in some countries 50 is put as the age break in terms of obviously when a woman can have treatment. Okay, what we're saying is that in the bulk of situations it probably happens that it's before 47 years of age. Okay, but I think some of the clinicians, I think somebody from, I think it was John Kennedy from Sims, said when they were reviewing their files back in February, I think there was 160 cases over a number of years where the women may have been over 47 years of age. So what I would say is that obviously it's really the clinician's viewpoint as to whether that's possible, whether that puts the child at risk or whether it puts the mother at risk. In terms of the... Oh, sorry.
On the age limit, is there an age limit on the surrogate mother?
I don't really, I don't actually have that information. I don't really know if there is an age limit on the surrogacy mother. Is there?
Bill? No, sorry.
In general?
No,
well,
I suppose the criteria for surrogacy would be that that she would have had a child already, so that she would have had the experience of pregnancy. But I don't believe there's an upper age limit.
And then, sorry, just in terms of, I obviously made a point in terms of the registry. I know this was something that was mentioned by a number of clinicians back in February. And I suppose one of the things that was mentioned is really kind of, obviously, if somebody comes to the age of 18 and they're presented with a birth cert, and on the birth cert it says donor conceived. So there's two issues there. First of all, you know, they may not have been told that, and obviously that can be in certain situations, so that could be a huge shock to them. And the other thing is they may be aware of that, but also they may not necessarily want that appearing on their birth cert. Okay, so I guess there's two different situations. What I would say is that, and I'm not 100% sure, so maybe this can be clarified, is that I don't know whether it's proposed within the Children and Family Act is that there will be available two birth certs, okay, for that particular person. So one where if they want to have it on the birth cert, it is included, or one where they don't want. So I'm not 100% sure whether that is the situation. But what I would say is that obviously if they were to come to 18, they may not want it, and also they may not be aware of it. So I think that's probably quite a dangerous thing to put in there without due consideration.
Thank you. And Ms. Rose?
Yes, there were two questions, I think, aimed at me. One in terms of the reason why I did my PhD, which was in Australia, was looking at the history of the Australian stolen generations and adoption practice, and I worked in link-up services for both. It's totally unrelated to religion, kinship displacement, and kinship, so the Iona Institute or anything else.
Oh no, I was just asking, were you the same person that did the study,
yes,
the submission
yes,
from Iona?
Yes.
That's good, yeah.
So basically, there was a frustration that the kind of research that was going ahead, like Susan Gollenbach's, validated, for example, parents being given a choice whether they tell their children that they're donor conceived, and often asked the parents how the children were doing, and then had results that were reported as the children are doing fine. And I had a huge sense of frustration about that, which led me to my PhD. And there's a list in what I've provided you of proactive donor offspring around the world. And those are the people that you really need to consult with, rather than people like Susan Gollenbach, in terms of really understanding the long-term implications, because it's when we're adults that finding out that you've got 30 or 40 half-brothers and sisters has a major impact on your identity. That's when you're really grappling with the real stuff. So I just wanted to draw your attention to all those proactive donor offspring and the kind of things that they've had to set up in their own time and with their own funding, because there is no place for us to turn to say, look, I need some help with this, I need some funding to set up this service. So firstly, I wanted to draw your attention to that, and as a trades union representative, I think you would understand the importance of...
I'm no longer a trades union rep, but...
Okay, but the importance of having individuals representing themselves, rather than having experts over people. The other thing is, you know, I'm not arguing, I've identified for a significant period of my life as gay. I'm not arguing that, but what is seen as reproductive rights, or a gay reproductive rights, is actually, in this instance, seeing it as a right to have a genetic child that's actually somebody else's. So if there's a reproductive right, there's a duty to provide that, to provide gametes. I don't think there's a duty to provide a child to anybody that's infertile. I don't think that is a duty our society owes those people. I think that we need to really come back to base and think about, if somebody wants to adopt a child, they're screened. A child isn't made available just because they want them. There's a sense of they're only removed from their genetic family as a last resort for child protection. The fact that there's a group of people waiting and wanting to have a child doesn't create the supply. The demand doesn't create the supply in adoption. So the fact that people might want to have a child through donor conception, whether they're gay or whether they're not, is the issue at hand in terms of what is in the best interest of the child, what level of identity fragmentation can be facilitated, funded and promoted on behalf of these groups that want to have a child. And that's really the issue. It's not a homophobic argument, and the difficulty is that when you actually say, look, these practices are inherently flawed, people think that that's a homophobic argument, but there's plenty of gay people that will say that they don't support surrogacy. So it's not.
Ms. Rose, Deputy O'Reilly, had you another question?
No, I don't think so, Chair.
Thank
I think
you.
we've heard enough. Thanks.
Sorry, Professor Hayes.
If you don't mind, I'd like to...
And I apologise, I called you doctor now.
Yes. No. Call me Noreen. It's fine. Just on the birth surrogate certificate, it was really an illustration I was trying to make about the way in which we use language. And I was simply saying that if a situation arose where a surrogacy certificate was to be issued to a child, in my view, we should call it a birth certificate. And the reason for that was because I think we should limit the extent to which children are made different by the processes or the procedures that we bring into the bill. And I think that's true across the whole bill. I would like to come just to respond, if I may, in relation to the research evidence around about children and so forth. It is true that historically research in this field has tended to depend on parental reports initially. However, more recent and contemporary research has engaged directly with children. This has by necessity been with children who know they are conceived in this particular way, because that's the route of access. There are other efforts being made to access the broader kind of remit. It's very difficult to envisage the child that might be done. I would also say that while Susan Gollenbach's work is the one that is so frequently referred to, it is, I think, because it stands up to scrutiny. But and as Professor Madden points out, the evidence on child outcome and on parent-child, largely mother and child, but parent-child engagement has been, broadly speaking, comparable to that of surrogacy children, donor children and children conceived normally. I would also say that there are systematic reviews where aggregate data has been brought together, and again, the evidence around the harm or distress is not emerging, generally speaking.
That's very interesting because, Dr. Rose, you were saying that there wasn't, that research didn't exist, but it's good to know that it does. So therefore, and we're going to have to look at that, because that's, if you can provide that for us, that's good. But just in relation to the point that was made earlier, we're referring to children who are donor conceived who are now adults or who have reached adulthood. So it's not interviewing the parents to ask them, are their adult children okay, or how are their adult children? It's actually interviewing the children themselves.
These were 14. I mean, her most recent work was with 14-year-olds, and I do certainly think efforts more increasingly are being made to interview and engage with younger children. But this is true of research with children, generally speaking. My field is early childhood, and it's quite limited to see. It's only now that we're beginning to see creative ways in research methods to actually access the voices of younger children.
Yeah, and is that work ongoing at the moment, just in relation to in this area?
In this particular field, it's very emergent.
Yeah.
Thank you, Deputy O'Reilly. Now, Senator Mullen, we did say you
yes, I have some questions.
With another question, and then we're going to go to Senator Wakefield, if that's okay. Watfield. Yeah. Okay. Senator Mullen.
Thank you, Chair. Now, I'm not going to tell you your job. I think Dr. Rose did want to say something in response, though, there on the research. So I'm very happy, if you're happy, just to give way to her just on that particular issue that was arisen there about research, because I'd like to say something about research at the moment as well. Is that okay with you, Chair?
Well, I just want to give every member of the panel an equal opportunity, and Dr. Rose has had many opportunities.
That's fine.
So.
Because here's
if you could address your question.
Yeah, and I will, maybe you can address it, because I don't know whether you were going to say what I was going to say, Dr. Rose, but I think one thing that is very clear to me from this whole session is just how complex and varied the issues we need to look at are. And I would certainly suggest, Chair, it would be a good idea if we were to devote some time to looking at the research and what it says in this area as a kind of a key aspect that needs to be looked at discreetly. That said, we need to be conscious that research isn't everything, because sometimes it's emergent or sometimes it's incomplete. Research is an indicator about the possible effects on people of what happens. But of course, research doesn't tell you anything about whether people's rights are breached in principle before ever, just because you can't show positive or negative effects, doesn't dispose of all the issues. You may be breaching somebody's rights, but it may be impossible to demonstrate that they have suffered harm. That doesn't make it okay to breach their rights. So we need to look at the research, but as Churchill famously said about scientists, they should be on tap but not on top. Okay? We have other issues apart from just what research shows in this area. Just on the subject of surrogacy, and please contradict me if I'm wrong on any of these issues, I don't hold myself out to have specialist knowledge or whatever, but I understand that Sweden is considering banning altruistic as well as commercial surrogacy. There are quite a few countries which currently ban surrogacy. It is not the case that the entire civilised world is moving towards a recognition that because some couples engage in this, or some individuals avail of this or want to avail of it, or indeed have a deeply personal need why they want to avail of it, that somehow the only direction public policy can go is to permit. I presume I'm correct in that this is not settled ground of consensus. This is a hugely divisive issue. I just wonder whether, in the light of that, well, taking the Swedish, and if I'm correct in what I understand to be the case in Sweden, is it because of situations such as you, Dr. Madden, have described? You're, if I understand you correctly, positing a situation that in order to prevent misunderstandings, heartbreak, problems, it should be clearly understood, even ideally before conception, but certainly as soon as possible, and certainly before birth, that the commissioning parents, so-called, not a phrase I like, but that the child is going to be theirs. But by definition, that means that if a birth mother bonds with her child, or if a child bonds with their mother, that is just not to be reckoned with in the final analysis. And that is kind of a consequence of wanting to regulate surrogacy in a way that is effective. I personally feel that is a perverse outcome, and I think a lot of people would be concerned about it, because it does seem to go against, I think, our deepest instincts, that if a birth mother is bonding with her child, that some prior contractual arrangement should be the reason. And I think that is why the Supreme Court in this country came to the decision that it did and overturned the High Court. But again, that's just my opinion. But I just wonder, isn't that the kind of the inevitable consequence, that one has to make these kind of Solomon-like decisions? That's once we practice to conceive as opposed to deceive, that's where we go with surrogacy. And in the light of that, I think it does come down, doesn't it, to a question of whether people think on balance surrogacy is a good thing. Should we not be considering here as well, whether we legalise it or regulate it or not, should we not consider whether there ought to be a public policy campaign to discourage surrogacy on the basis of the rights being violated as argued by our guests O'Reilly and Rose? It is presumably conceivable, pardon the pun, that you could publicly discourage something through whatever means the state uses, advertising, counselling. In other words, that the message would clearly go out. This is not something that ideally should be done, even though there are other ways, better ways to try and resolve the pain of infertility and so on. But because this involves a fundamental violation of the rights of the child, this shouldn't really happen at all. The fact that we regulate it really recognises the fact that we can't control, nor do we seek to control, people's travel to other jurisdictions to avail of very different legal arrangements there. But just as in the case of smoking, we don't criminalise smoking, we permit it. But by gum, we do everything we can to discourage people from engaging in the practice of it, including rules in relation to packaging and limits on advertising and so on and so forth. So I would like to ask all of our group here, would they accept that in principle this is something that we ought to discourage, given that the issue of rights being violated hasn't really been contested here, if I understand it correctly, not to put words in people's mouth.
One thing that you said, I made no comment on surrogacy.
Oh, I apologise. Yeah, okay, apologise. So that's the issue of can it, ought it, and could it be done that you would kind of, as I say, use public policy instruments to discourage the practice of surrogacy, separately from the question of whether one regulates it in the way proposed or otherwise. Now, Dr. Madden, you mentioned that the real reason that people go abroad is because legal regimes abroad are more favourable. But I just ask you, is that really so? I mean, is not a big aspect of this, the financial and social vulnerability of people in what we might call developing world countries in this area. I mean, there are countries in the Western world where this is legal, but it, to my understanding, and I could be wrong, it is not to those countries that people are going. That this issue is inextricably connected with poverty and financial vulnerability and disadvantage. And I would just ask you whether it's really correct to say that the primary reason is the more favourable legal regimes, or whether that is really separable from the financial vulnerability of people. Those are all my questions on the subject of surrogacy, so I'll leave it at that for the moment. If other things on birth certs and so on, but I'll hold them if that's all right.
Thank you, Senator. I think some of the questions were directed directly to you, Ms. Rose, so we might let you start first.
Okay, yeah, I think you're exactly right. In terms of my court case, and also the court cases, there's a list that I provided of court cases that donor offspring have and are bringing forward around the world. And research like Susan Gollenbach's didn't forewarn of serious human rights violations that have been found now in our favour in terms of the right to know your identity. And in Germany now, children have the right to know information about their genetic donor parents throughout their lives, and anonymity is overturned retrospectively. Of Norell's law in Victoria, it's all based on interviewing adults or children and saying everybody's fine. So, and as I say, the real long-term complexities, as in adoption and as in the stolen generations in Australia, you know, those children might be raised in happy, loving families, but the real consequences for adults of integrating their identity, of whether they want to know who their genetic family is, what their ethnicity is. You know, I was raised Jewish and then that was taken away. Other donor offspring are suddenly discovering that they're Jewish when they're in their 50s or 60s. These kind of lived realities and complexities are not appropriately understood, and the only real appropriate research that exists is in those other groups of people that have had that separation and loss. Adoption, the Australian stolen generations, those are really the roots that we need to turn to, because whilst this is a new notion, it's a social experiment, being human is not a new thing. And our human response to not knowing our genetic roots, to not knowing our genetic kin, has been well documented for thousands of years. So there is, unfortunately, this notion that it's happening anyway, so we have to legislate for it and we have to come up with the least restrictive, most liberal option. You're exactly right. That I don't think that's the right way to approach this practice.
Thank you, Ms. Rose. Professor Madden.
Thank you, Senator. So I suppose just in relation to the research issue, it has been aired, and Professor Gollenbach's work has been mentioned a number of times because she is the world expert in this area, and perhaps if it's not appropriate for me to suggest that she might be invited to give evidence before the committee in relation to her methodology and the types of studies she's carried out over many years. In relation to the ban on surrogacy in some jurisdictions, of course you're absolutely correct. This is not a universally accepted practice, nor have I hope I have never suggested that that is the case. It is prohibited in a number of jurisdictions for policy reasons. I suppose my view on that is that when you look at the evidence, in any jurisdiction where surrogacy has been prohibited, it has not worked. It has either pushed surrogacy underground with no protection for anybody, or it has forced people to go abroad to engage in surrogacy elsewhere. And that raises the risks of exploitation that you mentioned yourself. So the evidence shows that in any country where surrogacy is prohibited, people in that jurisdiction still avail of surrogacy outside of the national boundaries of that jurisdiction. And my view is that we should avoid that. My view is that we should not put our heads in the sand and say surrogacy is not happening. Surrogacy is happening. Currently in Ireland, it is happening by people going abroad and trying to bring their children back. And I don't think that that's an optimal situation. I think we should face the facts that people are going to engage in this, and we should regularise it and make sure that everybody is protected and that the rights and interests of everybody are protected. I suppose you also mentioned in relation to the birth mother bonding with the child and so on. Again, I'm not an expert in that area. I'm here as a legal expert. But I do know that it is very, very unusual, exceptionally rare, for a surrogate mother to want to keep the child after birth. it is estimated on the studies that have been done, it is estimated to be about 1% of cases of surrogacy where the birth mother changes her mind and wants to retain custody of the child after birth. And that is because the surrogate mothers, particularly where they are not genetically related to the child, they do not feel and never consider the child to be theirs. They consider that they are carrying a child for another couple, and therefore they never feel that bond, or they never feel that they want to be recognised as the legal mother, and they never feel that they want to have custody of the child because they feel it to be somebody else's child. So it's exceptionally rare. Of course it can happen, but it's, as I say, 1% of cases. You mentioned, I suppose, the issue of whether people go abroad, as I suggested, to avail of a more favourable legal regime. That is my understanding. You said that perhaps it's because of cost reasons. I have no evidence of that. My evidence is that people go abroad because of the certainty and predictability of the outcome of the surrogacy arrangement, which is that they will be recognised as the legal parents of their child.
Thank you. Chair, may I ask just two supplementaries arising out of Professor Madden's or Dr. Madden's answers?
If you can, yes, and I'll take Senator Warfield and then Deputy O'Connell.
Yeah, and again, just that might be something that would be useful for us to tease out at a future meeting. That what is the what are the reasons why people are travelling? Is it legal? Is it this financial disadvantage issue that I propose? And as I say, far from a statement, it was a question. But just two things. Just first of all, your response to what I asked about Sweden. Is that your understanding as well, that they are moving, if you like, in a more conservative direction, and that there are moves to abolish or to ban altruistic even surrogacy, and why that might be? And just secondly, the other issue I had asked you was about whether there ought to be a policy of deliberate or a policy of discouragement in the light of, because it seems to me that if you think that there are downsides to this for children, then that might influence your view on how we go forward in terms of whether we regulate on the basis that it's happening anyway. If you think it ought not to be happening, perhaps one might come to different public policy choices. Would you agree?
Okay, so in relation to Sweden, I don't have the information on Sweden to hand at this particular moment in time. But as I said in my earlier answer, there are a number of jurisdictions, obviously, that have gone that route of banning surrogacy entirely. And my response to that is that it won't work. That people will still engage in surrogacy, but they will engage in international surrogacy arrangements rather than domestic surrogacy arrangements. Your other point in relation to whether or not there should be a policy of discouraging surrogacy, I don't believe there should be. I don't see any evidence of harm arising from surrogacy in the research that I've been carrying out over the past 30 years. There is no evidence of harm in the studies that have been done of surrogate mothers, of intended parents, or of children. I think it has been shown to be a very positive way of creating and helping to build families for people who otherwise can't, and I don't see any reason to discourage it.
Thank you. Senator Warfield.
Yes, Chair, I think in all of this, and just to thank everyone, it's been really informative and helpful. I think in all of this, we should be mindful that we have in recent years a referendum for civil marriage equality. For many people, it redefined what it meant to be Irish. It recognised that there is no single proposition for family formation. It recognised that family formation is diverse. And I think that was well illustrated when children of heterosexual lone parents reefed down from the lamp posters that told us every child deserves a mother and a father. I just have one question. I wonder, could we bring the conversation briefly towards just in addition to that point, every week I receive representations, and many of us do receive representations from same-sex parents who, one of whom has no legal connection to their child. The knock-on effects are many in areas particularly like health, and leads to huge anxieties. But if we could just bring the conversation to the area of counselling, Subhead 3 in the general scheme says that the provision of information, each intending parent must also have received counselling from a genetic counsellor. Where there are 2 intending parents involved, the counselling should be offered to them individually, jointly or both, depending on the couple's preferences. I wonder if our guests have anything to say about whether this counselling should be offered before, in addition to after, or during and after. And if it is a requirement legally, should it be a requirement unless the state is prepared to offer financial support for that counselling?
Sorry, could I ask what head you're referring to?
It's subhead 3 in relation to subhead 3C in relation to counselling.
Subhead 3 of which head?
Which head is it?
Subhead 3 of which of the bills?
Head 38. Sorry, it's head 34. Consent, provision of information and counselling.
Sorry.
So it requires it before treatment. I wonder, should that be a requirement only before treatment? And if it is a requirement legally, should there be financial support?
I mean, we provide counselling to people prior to adoption, and unless we were prepared to move that counselling for people prior to adoption, I think this type of parenting is complex. It has complexities that you don't have necessarily in the more natural types of conception. We don't have these interventions or third parties involved. So I do think it's a good idea to have counselling, but from bodies that don't have a conflict of interest in providing the service, and for the donors as well, or people targeted as donors. I think there needs to be a neutral body that understands the significance of the kind of long-term complexities that can result, to provide informed consent. And the only way they can do that is if they're in contact with people around the world who are speaking as adults who are affected by these practices. Otherwise, how can you know what the long-term implications are if you look at only at studies up to 14 years of age? It's just not possible.
Thank you. Can I just clarify that I'm reading the right section? Is this the head which comes under Part 5, which is related to pre-implantation genetic diagnosis and sex selection? Is this... Head 34 is consent, provision of information and counselling. So it's in relation to consent for treatment in treatments involving PGD, HLA matching and sex selection. So it's counselling in this context we're speaking about?
Yeah, so in Head 34, Part 2B.
Yes, but it's as I understand it, in relation to treatments involving pre-implantation genetic diagnosis, HLA matching and sex selection.
The broader question is one with regard to counselling. So obviously we've just been through a process whereby we are considering the regulation of people using the title counsellor, specifically in relation to agencies that were setting themselves up, and that the need for regulation, I think, was very clear on that. But if I could interpret perhaps what the Senate, it's with regard to counselling for with regard to the option of assisted human and in any form. Should that be available? In the event that it is available, should it be preconception and also post-conception? And in the event that this was legislated for, is it your view that the state should be the ones, in fact, that fund it? I mean, if we're going to put it into law that you have an entitlement to the counselling, is it your view that the state should fund it? I think. Yes, okay. So that's
just maybe if I just mention in relation to surrogacy that it is provided for in relation to surrogacy, so that there would be counselling of the surrogate mother, the proposed surrogate mother, prior to engaging in this relationship, and that the costs of that, if there are costs associated with that, would be borne by the intended parents.
Can I just come in on the counselling issue? And if it's the broader issue of assisted human reproduction in general, I think that the evidence from research indicates that the more information and support that's given across from beginning through and on it seems to lead to the best outcomes for everybody. And so I would add to the bill a kind of an attention to the lifespan of the child into adulthood and as well. In relation to the costs, I mean, I think there are mixes and balances, but I think that the state obviously should contribute at some level in the broader sort of picture if they're regulating for this area in general. Could I just take the opportunity to address just two other points that were made? You mentioned about the need to carry out studies beyond 14 and that 14 is only so far. This is a longitudinal study that's being done with children from birth through. They will be followed up and up and up. It's the first of the longitudinal kind of data that's coming from that particular study. And I would suggest, as I did in the opening statement, that research, a longitudinal research kind of commitment, so that we get to know about the situation in Ireland and we get to actually identify the difficulties, etc., and the positives. And then in that regard, I think it's really important for me to just... Sorry.
It's just like I can hear it's for the people who are trying to control the sound here. It's not ideal.
And to point that longitudinal study was recommended by the Commission in assisted human reproduction. The other issue I'd say that is, I think when we talk about research, it's very important to have research which is looking at everything. Things that have been positive, things that have been stressful, things that have been negative. And the more research we have, the greater understanding we will have. So I have no objection to rigorous, deep research, which takes account of your work, Bock's work, other people's work. But the issue is to get that onto the agenda in this bill. I think we really need, I mean, we're seeking evidence from people contributing to the bill, and I think it's wonderful, and therefore I think we need to have research with individuals who have had unsatisfactory experiences. In my experience, the research that does show areas of distress and identity difficulties, belongings and so forth, has pointed to the absence of openness in the broader kind of context. More research can give us insight, and the more research we have with people who are directly related to children and adults, the better. So in that sense, I think research is really important. And I would say that where it has happened, and it is again, there isn't a huge field of it, but where it has happened, research with surrogate mothers has indicated no psychopathology in those mothers, and as Professor Madden has pointed out, very rare instances where there has been a bonding issue.
Okay, thank you very much. Deputy O'Connell?
Yeah, thank you. Thank you all for coming in, and thank you for your submissions and all the information you've given us. And I hope that we can take on some of your recommendations as the experts in this field with regard to this bill. And it's very easy, I suppose, for any of us that have children, I suppose, to not consider the people who get married, either to same-sex relationship or otherwise, and just cannot have children. And a certain amount of ignorance around this area, but as you read more about it and as you meet people that have used surrogacy services abroad, you kind of, I met a gentleman recently who's married to a man who has a couple of children via surrogate, and I was just so struck by how lucky those children were to be brought up in the environment that they were. So some, I suppose, I consider myself a rampant liberal, but at times my inherent bias kick in. But then when I listen to experts like yourselves, it's not about me, but I become more personally comfortable. This is it's a whole new area. And in particular, Professor Hayes, I think it's so important that we have this longitudinal data, that we're basing it on experts and facts, be they on top or on the bottom, the experts. It doesn't matter where they are, and their position is irrelevant to me. But I firmly believe in using proper scientific, not anecdotal evidence when we're making decisions. I do think, like most things in Ireland, when you're late to the table, you have the benefit of other jurisdictions. And we do all know, and I'm a community pharmacist by profession and have dealt with so many families in the last 15 years, where it really has kicked off in Ireland. And you see the desperation, the travelling to Greece, the complexities of getting prescriptions from other countries, getting them translated, getting drugs equatable, the work that goes on to assist people, either in the medical profession, the pharmacists, to assist people on their journey. And like that, I would agree with you, Professor Madden. It seems very clear to me, if this is not regulated, it will go underground, it will cause problems to the future. And in the case of, as Senator Warfield mentioned, where one parent in a same-sex marriage is the only one, it seems with a legal connection to the offspring, it's of huge concern to the parent who's not genetically, if something happened, the person. So maybe you could elaborate on some of your experiences there. With regard to the 1%, and I really do see it as the greatest gift. I don't think I'd ever be able to do it for anybody, to have a child for somebody who just can't. But this 1% that you mentioned of people that don't want to give the baby to the genetic parents, is that in the regulated or in the unregulated sphere that happens? If you could just clarify that, because surely if it's in the unregulated, if you improve things, things should improve. It's very interesting, Professor, has no psychopathology from all of that evidence, but that's really important, because they're the things that I think normal people out there are concerned about, the knock-on effects on children in the future. So maybe if you could just address some of those, and I very much, as a member of the government party, will be taking all of the experts' information on board and feeding it back to the Minister, so that we hopefully can bring forth a bill that is fit for purpose and leaves people with legal certainty. And like anything, this is a very personal and private matter for couples. And I suppose I thank anybody who's come in here and told their own stories, because it's of huge value to the likes of me, who's fairly, I suppose, ignorant on this whole area. So thank you.
Thank you very much, Deputy O'Connell. So just in relation to the first point you mentioned about the example of the same-sex couple, where one of them is genetically the father of the child and the other parent who's raising the child doesn't have any legal relationship. That also happens in heterosexual couples. It's not just in same-sex couples, because at the moment, if a couple goes abroad for surrogacy, the genetic father can be recognised. He can come back and apply to be recognised as the legal guardian of that child. But his wife, who's raising the child as her own, doesn't have that right, even though she's also the genetic mother. So he has the right as genetic father to be a legal guardian, but she does not have the right as genetic mother to be legal guardian. So under the Children and Family Relationships Act, she can apply after a period of time, having lived with the guardian after 2 years. She can apply for recognition of her role. But during that 2-year period, can she sign a medical consent form for the child? Can she apply for a passport for that child? What if the couple were to separate or divorce? Would she have any rights to access in relation to that child that she has raised as her own? So it's not just in same-sex couples that I think that problem arises, and I think it's crucially important that we address that. In relation to the other point that you mentioned, which was in the 1% statistic that I raised, that 1% is from the United States. The other figure that I have is from the United Kingdom, which is about 4% of cases in which the surrogate changes her mind. But that is from a study that was done in 1998 by Professor Margaret, who was commissioned by the UK Parliament at that point to look at the issue of payments to surrogates. And as part of that study, she came up with that figure of about 4% of cases in which surrogate mothers changed their mind. So that's probably out of date at this point. I could certainly access expertise in the UK to find out what the current figure might be, but it's difficult because the only way that you can access that is, in a sense, by looking at the number of cases that have come through litigation and so on, and that, we can get some estimate of that, but it is exceptionally rare.
But I suppose it could be argued that the more information people have, the more informed, the more the guidelines are laid down, the more it's very clear to everybody at the outset what's happening. Surely it would be, you could argue that should decline, that figure. It should become less as people become more aware.
Correct.
Comment?
Yes.
So what I'm hearing is a lovely sentiment about adults wanting the best for adults, and I think we all want that. And I'm not an expert, I'm not a professor or a doctor. I may only have 2 years of medicine, but it's enough of an understanding of embryology, and I come from a medical family of 3 generations. But what I'm hearing is, what I've been doing over the last 3 years, I suppose, after my master's in psychology, is listening more than anything. And I hear this sentiment of wanting others to be happy, and that's what Ireland is now working towards, and thank goodness. And I too am supposedly a rampant liberal, and I want everybody to have equality and rights, and the right to be happy and the right to choose whoever it is they want to love, and all of these things, thankfully, we're improving on. But what I do see standing back is that all of us adults have this great sentiment of wanting everybody to have everything that's going to make us happy. Among those sentiments is the really emotive subject of not being able to have a child. I've been in that position, thinking I would never have a child. It is the deepest pain you can possibly imagine. Not probably the deepest, other people have others, but it is a profound pain, and you will do anything. You will try and find a child to pick up off the street from a bush. It is painful. But that emotion, we can all relate to that, so therefore I can be very sympathetic to this cause. And same with same-sex couples. I mean, who doesn't want, gay people in Ireland have suffered, not just in Ireland, horrifically. And so again, that arouses emotion in us, because we want them to have happiness and equality and children, the most valuable thing. But all of that emotion can blur everything and can prevent us from just moving our attention there, because all of that is very positive. And we're not seeing with foresight much further down the line this group of children who may be happy living with somebody who's not related to them, because that person is a very good and loving person, and there's always going to be, with a large amount of people, there's going to be a certain amount, just statistically, who are going to be very happy with that situation. But there's still a substantial amount of people who are saying, no matter how loving this family was, and no matter how right it is from an up there ideological point of view, I'm still suffering. And we have to take our eyes off all of us adults who want the best for each other and look at this group of children who are part of our ideology, and separate that out and listen to them. And I think that's what I've been doing for the last few years, is listening to adults talk, listening to clinics talk, which I can't help seeing as very marketing and commercially orientated, and there are lots of instances of it. But when you talk about, listening to the experts, we have on our submission thousands of people who have lived this experience, and we can't discredit that as evidence. They're not professors and they're not doctors, but they're human beings who've lived a life. And it's not saying that a gay parent could not be the best parent in the world, or the worst, because we're all human. Gay, straight, one's not better than the other. So you have good parents in all situations, but it's just saying that unfortunately life, we cannot solve all of these inequalities and difficulties. I cannot give you a child because you are a wonderful, kind, loving person. Therefore I will go and find a donor, but a donor is a human being. I will go and find a woman to sacrifice her connection with that child so that you can fulfill that longing you have. I don't see an answer that will fulfill that longing and let us all be equal in that way, because unfortunately nature hasn't given us that ability. And it's still, yeah. Thank you.
I suppose I wasn't saying that we should be making sure that everybody's happy at the expense of the children. I think that was actually, well, that's your interpretation. But what I was saying, what I am saying is that that children can often have very positive experiences. And while I'm not arguing, of course, and I've seen your submissions and aware of where you're coming from, I believe, and I think that the scientific community understands, that the longitudinal study is the only way we can get hard data on this. And when you talk about, I suppose, the effects, well, the effects that we're looking at of probably illegal surrogacy or sort of ad hoc arrangements is in the unregulated environment. So surely there will, if it all happened in sort of, you know, cloak and dagger off to America, donor egg, donor sperm, all of that happening, that of course there's going to be collateral damage as such from it if it was in an unregulated. But if you have a regulated environment, it seems to me only logical that the outcomes will be better, that there won't be this vacuum, there won't be this...
But for whom? Sorry, you don't...
You know, and you know, I'm just saying that we have to base our decisions as legislators on longitudinal studies and on the benefits of regulation. Sure, if there was no benefit to regulation, there's no point being here, you know.
Thank you, Deputy O'Connell. Dr. Rose.
In terms of my experience of the way you're presenting and what you're saying,
the way I'm presenting?
Yeah, you speak with real compassion and concern about the inability to have a child. You started off saying that. But I don't know if you know any people who haven't known their genetic parents. Do you equally have compassion for adoptees that have searched for their genetic parents and then have gone through complex processes of trying to integrate those people into their identities and into their lives? Because really, it is important. Do you understand my question? Sorry, you look confused.
I'm sorry, I'm the questioner here today.
Yeah, no,
but that's okay.
No, just for a moment. The purpose of the hearing this morning is to examine all available evidence, and
yes.
You know, and it's wonderful, and the conversations are wonderful. But we're here, and I think Deputy O'Connell was making a point about the longitudinal study, and that is really the only available evidence as such.
My answer is addressing that in terms of the only longitudinal studies that you will find that are really appropriate to make informed decisions are from adoption, are from kinship groups that have been separated from their genetic family. Otherwise, if you don't have any kind of precautionary principle, you set up a situation where you can do anything to the next generation, and then you have to accumulate evidence, scientific evidence of harm after the event. You have no precautionary principle in place with that type of logic. So I'm arguing for a different approach where you base your understanding of the best interests, not the welfare, the best interests of the child on the research that we have already. And you don't just leave it to the industry and the industry users to do whatever they want and then collect scientific collateral damage over the following decades. Because I really believe as legislators, there's a duty of care to the most vulnerable people, and those are the children. So yes, there's loads of, if you want to bring in scientific evidence, bring in people like Pauline Lee. There are professionals who've worked in the field of adoption. There was Alexina McGuinney, who got an MBE. There's Pauline Lee, who got an Order of Australia for particularly transferring knowledge from adoption to donor conception. But the problem with this framework that's currently going ahead is that it doesn't transfer our knowledge from adoption to donor conception. It pretends it's a new and wonderful treatment, and that we have to argue or we have to assess harm after the event. And that's just, I don't believe that's responsible.
That's fine. Well, that's your opinion, and we have you in here to hear your testimony, and thank you for it.
I just don't think it's been established that the harm exists. With the greatest of respect, I'm not hearing
with adoption.
I'm not hearing the evidence that the harm exists, and that's why. So when you refer to doing the assessment of the harm, I'm just not convinced that harm necessarily exists. But look, we're here to hear from everybody. So, you know, I mean, we've a long way to run, I think, on this piece of legislation. We've a lot of scrutiny we're going to have to get through, Chair.
You're right. Apologies, I had to leave unexpectedly there. I'm losing the run of speakers now. So, have you finished?
There were no speakers indicating after Deputy O'Connell, Chair. My apologies. I didn't. Oh, so you weren't on my list, Senator Mullen. Sincere apologies.
Senator Mullen.
Yeah, great. Just very briefly, I think because Deputy O'Connell picked up on, I think, some of what I said in relation to research. I think it's really important that we take a very honest look at whatever research shows. I think that's the principle that must always guide us. We have to be conscious, as I said, of issues of objectivity, tests for that, understand what research is capable of showing us and its limitations, because research doesn't always cover all of reality. We need to know that. It's an imperfect world. And I think the real point I was making, Deputy O'Connell, was there are things that research just can't give us the answer to, which is a separate question, which is, are there breaches of rights involved here? A person may be upset because their rights have been breached. It may not be demonstrable that they've suffered harm, but that doesn't mean that we should allow their rights to be breached. And this is why I think a question that I asked of Dr. Madden was important, which is, do you think, in relation to surrogacy, do you think it ought to be discouraged? Do you think there's something wrong that should be acknowledged at the heart of it? Your answer to that will determine an awful lot more of what you think about whether it should be regulated in a way that permits. We can also talk about regulation that actually bans, and I made the point that, my understanding, that Sweden seems to be moving in another direction, which would suggest that they know something, and we often cite the Nordics as being very enlightened. Countries like Germany, France, they're not back in. Well, let's not make distinctions between countries, but you know what I'm trying to say. This is far from settled territory. There's obviously some very serious considerations to be reflected on. But just to come away from surrogacy, as I said I would, the Law Society Gazette talked about, in the context of this scheme, as I understand it, they said that we're sleepwalking into the possibility of large-scale human tragedy and emotional devastation as the government legislates for birth cert legal fictions, quote unquote, in cases of assisted human reproduction. Do I understand it, and again, I'm very much in the hands of our experts here, but do I understand that what it is proposed is that birth certs will effectively be falsified so as to hide assisted human reproduction realities, in that it would not be knowable from the birth cert whether your parents were your natural genetic parents or whether they were donor parents? And I'm asking this in a very neutral way, but it seems to me that the answer to that question would raise an awful lot of other questions. Like, I think in everything we do, we proceed on fact and truth. If it's a thing that there is any, and it's related to the issue of whether, going back to Dr. Hayes' issue that Dr. Hayes reflected on, whether people should be encouraged to be open with their children or whether they should be required to be open with their children. It seems to me that if we're talking about birth certs occluding in any way reality, then we really have to be honest and say that this whole process, while intended to be helpful for some, for adults, involves either children being confronted with very complicated realities, like a birth cert that says your genetic parents, your legal parents, your birth mother, or in the alternative, children either being lied to, or you could say being lied to by omission, by not being told something which they might have an interest in knowing. I would be grateful for some clarification on what exactly is proposed in all of this, but it does seem to me, on first principles, that anything that hides or obscures should be considered a problem. And I have to say my thinking has evolved on this, because I hate the idea of children being kind of confronted with, as I say, complicated realities. But maybe we need to reflect on the complicated realities we're proposing to legalise and regulate, because it does seem to me that there is no way of knowing what a child has an interest in knowing and when they have an interest in knowing. And the parents may have a particular view, but if it deviates from what is actually the truth, then I just think there are so many problematic issues there. So I would ask people, do they consider that perhaps it ought not to be a matter of tell your child what you think they need to know, when you think they need to know it, or whether this process, if it is going to be legally permitted, that implies a certain social conferring of approval on it, then that process perhaps needs to require that information is shared, by all means in an appropriate way, but that anything else really is engaging in an untruthfulness that really snowballs over time. And that really having the aspiration, which is what I heard Dr. Hayes talking about, that parents would be open with their children, is a long way from securing children's rights in this area. That would be what's going on in my head, and I'm very, very open to correction on the facts, or indeed a different opinion being offered as to because in all of this, people talk about constantly the well-being of the child, but it does seem to me that concern for the child's welfare seems to be always predicated on adults getting what they want, fundamentally. And I just think that does need to be interrogated. And another example of it, I suppose, would be this requirement on donors to keep the register updated with relevant information. For example, if they're diagnosed with health conditions. Is that really respecting a child's right that the donor would be the one? Because don't we really know in practice that is going to be, well, dare I say it, is it possible that would be more honoured in the breach than the observance? And shouldn't really be, if you were going to permit this area of activity and regulate it, that the requirement ought to be on anybody providing the service to maintain contact with donors, and that they would secure that information, and that they would be responsible to the children, those providers who do make money out of this process, that they would be responsible to the children, either in the present or in the future, for gathering such information. I really wonder at this idea, as I say, and I wonder at the mentality behind it, by kind of putting it on to donors, that they have to somehow keep, when I don't think there's any reality to that. I just don't. I think it's a joke.
Thank you, Senator Mullen. Professor Medden.
Thank you.
And Professor Hayes.
Thank you, Senator. I suppose just to come back to this issue again that was flagged earlier about whether surrogacy should be actively discouraged. I don't believe that it should. I certainly would take issue with the notion, and this is not your language, but language that was used by somebody else in the room this morning, who described infertile people as desperate people picking up children from under a bush. That's not how I would depict people who have difficulties with childlessness. I would depict people who enter into surrogacy arrangements as responsible, committed, caring adults who want to have a child of their own and who will be fit and loving parents if given the opportunity. So I would rather see them in that light rather than with the notion of desperation and willing to go to extraordinary lengths to have a child. So I don't believe surrogacy requires to be discouraged. I think it should be properly regularised and protected. In terms of the issue of birth certificates, I think we have to acknowledge that in some ways perhaps they are already legal fictions. We don't test every child who's born in this jurisdiction to find out whether or not their father is really their father before he is entered on a birth certificate.
Oh, there's a presumption of truthfulness.
There's
That's a very different issue.
There's a presumption.
With the greatest respect.
There is no. I'm saying it is a legal fiction. If we actually wanted to make absolutely sure that every child was the child of the father who's written on their birth certificate, we could carry out genetic tests.
Yes, but with respect, it's one thing to put an unusual and onerous obligation on somebody. It's another thing to facilitate direct telling of a falsehood. I don't think you're dealing with comparing like with like here now.
There is already a direct telling of falsehood. For a woman who has a child through donor insemination in this jurisdiction, her husband's name will be entered onto the birth certificate, even though he's clearly not the father.
And do you think that's acceptable?
No, I don't think it's acceptable. I don't think it's acceptable. I think every child should have the right to access the identity of their genetic parent. I don't think it's acceptable.
So any legal fictions are inappropriate?
Absolutely. And I think that studies show us, again, that between 5 and 10% of children who are born in natural reproduction are not the child of the father that is
I
acknowledged on the birth
think that's a
certificate.
separate question, to be honest with you. I don't, where there's a procuring of gametes for the purpose of reproduction, there is a very active intervention, and it is known in advance, and it has none of the, shall we say, the other messiness of life that might cause, you know, in fairness, it wouldn't be, I don't think you'd be comparing like with like there.
And my argument has always been that children should have access to that information. Always.
Professor Hayes.
Just in relation to...
So that would include, sorry to interrupt, that would include the birth mother in the case
Yes.
of surrogacy as well?
Yes, absolutely.
Yeah.
Yes.
Just in relation to the observation I made in my opening statement about the birth certificate and so forth, I made it clear that the two things, I hope I made it clear, that the language of the bill needs to be more cognizant of the rights of the child. And in that way, we should limit the extent to which we create procedures and processes which mark them out as different. Births now happen in a variety of ways with a complexity of opportunities, and the proposal of a surrogacy certificate, I felt, it was not about giving the information about surrogacy that I had a difficulty, it was the fact that it was not a birth cert, and the proposal was that it should be a birth cert by surrogacy. Birth cert by donor, with access to available information on the complexity of the parentage of a child in whatever way it happens. And the research which is accumulating, and the field is new, the research which is accumulating is indicating that hiding or obscuring information around identity complicates the developmental trajectory later in life. For children, it increases the likelihood of difficulties and of distress. And so I would be certainly proposing that as much information is made available to children as is possible, and that parents are encouraged, and that the processes and procedures may actually, what would you say, feed into that encouragement by their openness, shall we say. Just to pick you up on one word that you mentioned, Senator Mullen, which was, you talked about child well-being, and actually I think it's really important that the bill talks about welfare, and it doesn't actually talk about well-being, which is a much more complex kind of concept, and which is what I think a lot of us are trying to kind of discuss and present the evidence about how we can maximise the child's well-being. And if I could say, in relation to the surrogacy question that you posed to Professor Madden, and I think originally proposed openly, I think that in information that is being made available generally, and not just to intending parents and potential surrogates, I think we need to actually discuss the complexities of it. We need to make the information available. I don't think there is sufficient evidence from the point of view of what the responsibility is, what the action we're talking about is. I don't think there's sufficient evidence to be categorically disencouraging it, but I certainly am not against the research of experts of experience. I think experts of experience have a lot to contribute.
Well, could I just tease that one out with you? Because you don't need evidence to show that people believe that there is a fundamental breach of rights here, in that there is a sundering, well, in the case of surrogacy, there is a sundering of the child's relationship with the woman who gave him or her birth. In the case of donor-assisted human reproduction, there is a sundering of the relationship with the genetic parent. And I think many people will find that one much more, will see the injustice of that one much more clearly, because there is such focus these days on people knowing who they are and genetic research and all of that, the more we know, etc. But you don't need research to know that there is a controversy about that, and arguably it is not a matter for what evidence shows. It is a matter for what we as the value that we ascribe as a community to the maintenance of the genetic and birth link, and that if the community agrees that, all things considered, this isn't a great idea, that there is a deprivation of the child's rights, regardless of whether he or she suffers harm or whether he or she suffers demonstrable harm, which is a different consideration, there is an issue here. And would you agree that perhaps that is an issue that should be put, at the very least, that this is a view that is legitimately held in society, that there may be an injustice to the child here, and that this is something that is put to people? Because we really need to accept that what the law says influences behaviours, and as I said, I think there is a very stateable case that there is a legal injustice here. And therefore, I don't see how it can be reasonably excluded from any counselling setting.
And I think in that regard that perhaps Professor Madden would have more to say about the legal discussions and findings around that. There's no doubt that on issues of rights there are frequently tensions.
Thank you.
Could I ask just for an answer? Perhaps maybe I should wait till Dr. Madden comes back, because it depends on who wants to answer it. But I was asking some very specific questions about whether it should be that donors are required to keep the register updated, or whether that obligation should be placed on providers of this service.
Can I respond to that? So I'm friends with a donor offspring in Denmark who is desperately trying to track down 64 families who all have used a donor who, after the event, has developed a fatal disease, and all those children are predisposed to that disease. And there's nothing that requires the clinics to inform those families of that situation, and that donor offspring has spent 10 years trying to track down those families. I've got another friend in Australia who has discovered that she had a predisposition that her donor informed the clinic about of breast cancer, and she and her half-sister through donor conception developed breast cancer, but they were never informed by the clinic about that predisposition, even though the donor had gone back to the clinic and said, please, can you let these people know? So I think it's really important that you have legal, I think in this bill it says may. They may provide medical information, they may update. That's not mandatory, that's a kind of they might not. I think you need something in law that means that those people are accountable. If we're in the situation where we end up predisposed, or like my friend Narelle, who died of a preventable genetic disease because of somebody's negligence, they should be held to account.
Thank you very much. Deputy O'Connell. Deputy Durkan.
Thank you, Chairman. I think that we need to establish one or two things. First of all, this is a very emotionally charged subject, as we know from previous discussions and from what we read, what we've seen, and the legal cases that have taken place, hugely emotionally charged. I believe that Professor Madden has made an interesting comment in the sense that judicial approval or judicial oversight at the initial stages is something that I think is probably vital. How it operates and how it will operate smoothly and without too much administrative hold-up, I don't know. I'm not so sure about that. Now, I would have, like everybody else here, would have met adoptive parents and dealt with them, adoptees, and have dealt with them, and the family of donors, and we still do. There are a few things, I think, for instance, the health issue, the transmission of particular weaknesses, genetic weaknesses. I think that's something that the surrogate parent and the proposed parent should know about. I think that's something, and I think that comes into the legal part of it as well. And while I'm not a legal practitioner, I think that it is hugely important that we must recognise that we cannot legislate for everything. It never was possible to do that, and never will be possible to do that. Nor should we put our own bias on legislation in one shape, form or another. We have to do the best we can. We have to do it in an impartial fashion, with all due regard for the ethical, the medical, the morality, the whatever, and try to come to the best decision. This is going to take some considerable time, Chairman. It's not going to be a thing that we can achieve overnight, I have no doubt about that. But we need to do everything that we can, insofar as we can, to get it right. And I think for anyone to suggest, that we're infallible, we're not. Neither does anyone else that I know about around the table. Some of us might pretend it sometimes, but it's not true, I can assure you. So what we do really need to do, is to give it the best shot we can, to eliminate the possible obstacles, having regard to what has happened in the past, and lots of things have happened in the past, and try to come to a conclusion as to what is the best way to proceed. And we do have to have regard also for two issues. First of all, there are the people who have a yearning and a longing for a child and can't, for whatever reason it is. And there are two groups of people then, those who cannot afford and those who can afford. They emerge then at that stage. So under our constitution, we are expected to legislate in a way that makes it possible to even that imbalance insofar as we can, without deprivation of entitlements or rights on one side or the other. So I think that, you know, based on the information that we've received this morning, is hugely important, Chairman. And I think we need to use it in the course of the drawing up of the legislation or amending the legislation or whatever the case may be. And we have a lot more opinions to take on board as well. But we as legislators have to take on board the views of the experts that are presented before us. We don't know what expertise is going to emerge in 20 years' time.
Thank you, Deputy Durkan. And
time, would I? Or do you want to go?
I was going to ask a question myself.
Go for it, Chair.
Thanks very much, Deputy O'Connell. Just on the point, and you might have been going to bring it up yourself, but on the point Deputy Durkan makes, this is extremely complex medical, moral and social issue and issues that we're talking about. And the medical technology is changing all the time, and our legislative process is changing all the time. So, for instance, the same-sex marriage legislation that's now in place, how does that affect our proposed legislation on assisted human reproduction? Because that puts now on a legislative basis in Ireland much more complex marriage relationships, which can lead then on to much more complex assisted human reproduction procedures, which would be legal in Ireland. So is it going to be possible for one piece of legislation to cover all this? Or should the legislation be broken up into different sections? So, for instance, should there be a piece of legislation on surrogacy? Should there be a piece of legislation on other elements of assisted human reproduction, and not try to put everything into one bill? That's a tough question.
I suppose just in relation to the issue of same-sex marriage, as far as I can see from the bill, that's already been catered for in the draft in terms of access to treatment, that there is no discrimination as between a heterosexual couple and a same-sex couple in terms of access to treatment. So I don't think there's any need to revisit that issue in terms of making it compatible with same-sex marriage. In terms of the legislation that I've mentioned already on surrogacy, I don't believe that it's necessary to have a separate act on surrogacy. I would rather see it within the same framework, I suppose, as other forms of assisted reproduction. Of course, it is different in some respects, but in most cases, and certainly as this bill envisages, it will be done through use of IVF, because the surrogate mother is required not to use her own eggs. So it has to be through an embryo transfer. So therefore that can only be done through the IVF process and through the IVF clinics, which it is proposed to regulate through this bill. So it kind of makes more sense for it to be all done to ensure adherence to best international standards and best practice and all of that, and subject to the supervision of the regulatory authority that's proposed. But I do think that that part on surrogacy certainly needs to be revisited. I know I've said this numerous times already, but I think it is crucially important to get that right. I don't imagine that there will be floods of numbers of people who will avail of surrogacy. This is a small country. We're not going to have hundreds and thousands of people availing of surrogacy. It's more likely to be in the figure at the moment, I think, there's probably something around the order of between 50 and 100 couples in Ireland who've gone through surrogacy internationally and who are awaiting, trying to regularise their relationships with their children. But I could be wrong on that number, because I'm not in practice as a solicitor, and it might be that you might get that information from family law practitioners. In terms of the screening, the health issues, I suppose, of surrogate mothers and intended parents, I think that's absolutely necessary for every adult who's involved in this process, and I think that that's again where the oversight of a regulator and the drafting of a code of practice and drafting of best standards will come into place, and that's how you link that with the licence that's given to a clinic, that you ensure that they adhere to best practice and standards in that respect. So I'm not sure if I've answered all the points that have been mentioned, if I've missed something.
No, that's fine. And just one other point on anonymity. If a donor, say a sperm donor, makes a donation and assigns an anonymity form, I understand that is the case in some jurisdictions, that you make a donation but you sign a form to say that you do not want to be traced. I mean, is that something which should not be allowed in this legislation?
Well, it won't be allowed under the Children and Family Relationships Act, which we have already enacted. It just hasn't been commenced yet.
But if you have...
And nor should it be allowed. Sorry.
But unless you legislate against facilitating that practice abroad by providing funded services in clinics here and then allowing for that abroad, then basically you will have different batches of children with entirely different rights. Those people that are conceived abroad and those people that are here, and some will have the rights to know their genetic identity and some will not have those rights.
Can I just clarify on that, that under the Children and Family Relationships Act, clinics here cannot use sperm that is imported from abroad unless it is identifiable. So obviously that doesn't stop people themselves from going abroad
They
to
can
clinics.
prepare people for...
But we can't stop people at the borders.
I can give you examples. In England, they actually prepare people and actually facilitate people to go abroad, for example, to Spain. So they get all the medication needed to set them up to go and then have donated anonymous gametes abroad. That does happen. And that's after my court case that established that we have a human right to know identity. So it does happen, and there are intentional, I think, loopholes made to allow that to happen, and I hope that you close those.
Deputy O'Connell?
Yeah, just to make sure there's nothing been coming out of this committee that's not what I said, or that any of us, I think, said here. I'm not talking about making everybody happy. I never mentioned anything about making people happy. And to, I suppose, suggest that some of the recent referendums were based on providing happiness for adults. I fundamentally believe in children being reared in a loving environment, whatever makeup that family is. It's something I think is fundamental to our society. Those people that adopt children, those people that have children. And again, as a medical professional, for women and men who have gone through IVF and have dealt with the heartbreak of multiple miscarriages, time ticking by, to suggest that anybody would abduct a child to satisfy their inner need, I think is something I wouldn't like to go out as the view of this committee. This, for me, is about children's welfare, and it's about the family unit and protecting children to the future. And it is interesting that, you know, we have had a history in this country of eldest daughters' children's been passed off as the mothers, various people who are purported to lead celibate lives, having children and their identity not being known. We have a long, hard history of hiding the identity of children within the family unit with no records. And as Professor Madden said, it's about, I think it's 1 in 10 children in the marital environment are not that of the father in the relationship. So I think it's high time, you know, it seems to be high time a lot of the time in here, but that we just sort of stood back and accepted the reality of what's going on. And our job in here is not to legislate for happiness, is to legislate to make sure that people are protected, children and families are protected, and that we, I suppose, have sympathy for people's situations that some of us, thank God, have never had to personally witness. Thank you.
Thank you.
I'll briefly answer that, because I understand that came from my comments about people making people happy. It was just really to put it into simple language that I still hear adults looking after adults more than anything else. And I think adults wanting the best for children is very easy to say, but the reality of it is that these children are growing up, the substantial amount of them unhappy. So I think it's...
Sorry, in your opinion, and not in the evidence of the longitudinal study that has been presented before us by the professors in this area.
Up to the age of 14.
Very clear. I think we have to be very clear that it's evidence this committee deals with.
Up to the age of 14, there is evidence.
And as explained by Professor Madden, it is a longitudinal study. They'll be 15, they'll be 16,
yes,
they'll be 17, they'll be 18.
There is evidence from the submission, what we have submitted, of groups, thousands of people around the world. Now, they may not be part of a research study at the moment, but they are still very valid human beings who have suffered.
No one's suggesting they're not.
And I just also wanted to correct the part about desperation, but I did not intend to say that people would go and abduct children. That was just an effort to explain the desperation. And there is a certain, I don't know what the right word is if it isn't desperation, of not being able to have a child, but yet procuring somebody else's child. There is something that leads to problems. You know, if I'm not fertile and a woman beside me gives me her egg, that is her child. And from the child's point of view, that doesn't change.
In your opinion, as a witness at this committee?
From the child's point of view.
I think our guests, all of them, deserve better than to be subjected to what I'm hearing now in terms of their opinion. We all have our opinion. And everybody here is giving of their time, and especially our guests, and all of them deserve huge credit, Chair, for coming here, speaking to their personal experience and to their professional experience and knowledge. And I'm very, very happy with what each person has done here today.
As am I, Chair.
And are doing us a good service.
Thank you,
I don't think we're well served by this, in your opinion.
Thank you for your advice, Senator. But we are here to discuss these issues, to see if we can bring in some clarity to the legislation. And if it requires some robust debate, I think that's allowed. I don't think anybody is being abused here.
The courtesies, I think, are
Thank you very much.
Not quite.
Deputy O'Reilly.
I have a point of order, Chair. Senator Mullen seems to be making a point that depending on one's personal preference, one should take a particular attitude in raising questions with the witnesses. That's not the way it's supposed to happen. We're supposed to ask all questions, even questions the answer to which we might not agree with ourselves. But we have to ask the questions, because based on those questions and their answers will be the legislation. So pretending to sidestep it and hope, that we'll get an answer like presumption of truth in relation to a birth cert, I've never heard that before, because I've looked at a good few birth certs where there's only one name in the birth cert, and I'm sure many other people in this room have done so, and the 10% has been referred to as well. We also know about that. So let's be honest with ourselves as well, and let's deal with the situation that prevails in our society, in all, with warts and all, and there are many. So let's not be too prescriptive in the way we go about it.
Thank you, Deputy Durkan. Deputy O'Reilly.
Thanks very much, Chair. Ms O'Reilly, you're saying that substantial evidence, and I hope I'm quoting you correctly now because I was writing it down as you were saying it, substantial evidence exists that children are growing up unhappy. So have you anything by way of actual evidence? I mean, there's a lot of anecdotal evidence, and my friend said this and all of that, but just by way of evidence that we could interrogate, because that's what we want to do. Have you anything more substantial than there are potentially thousands of people out there? Well, I mean, we have obviously the longitudinal study, and that's very welcome, because I think that will actually help us and inform us, give us something that we can critically engage with. Have you anything substantial by way of evidence, Ms O'Reilly?
I think this is one of the problems. It's the lack of power of that group of people, that there isn't. The evidence is here in this submission. So, as I was saying, we haven't got the evidence from Susan Gollenbach's research because it hasn't reached that far. So what we have to go by is I listen to people on the street as well as academic research. I've done a master's. When I say people on the street, people's lived experience, people's in Donor Offspring Europe, in Anonymous Us in America, in Spenderkinder, in all of these organisations around the world, in Tangled Webs. So that is the evidence, and it's there. There's many people to speak to invite here from organisations around the world who haven't been part of it, and they're crying out for research because their voices aren't being heard.
When you say they're crying out for research, that research is not done.
It's not done.
It's not.
Am I correct,
Okay.
Joanna?
No, and I think that's where we need to. Sorry, if you just allow me. I think that's where we need to get to is being able to critically engage. And as I said, the longitudinal study, that's great because we actually will have an opportunity to then critically engage with that, because that has to inform our work. It has to inform what we're doing. And just with regard to the comments about child abduction, I'm fairly sure you didn't mean to be offensive, but I think, and I have people in my own life, and I don't offer that as any kind of evidence, only a conversation I had with people who struggle with their fertility, and I think that comment would be deeply upsetting for them, and I'm sure that you didn't intend that, so you might take the opportunity to clarify.
Well, I hope to clarify that I said that was from my personal experience and from people. I also know plenty of people, and they will say that you look with longing at children, and you dream, and I don't
think you dream about or imagine that you'll abduct
I don't know where the abduction came in.
You said grab them out of the bush.
No, I said that you hope and you imagine or you dream that you would find a child one day under a bush, like what are those old stories of fairy tale stories? That's what I meant.
Okay, well, I'll check the blacks on that, Chair.
I meant that
I'm
in
happy
your
for that clarification. I'm sure you didn't mean to cause offence.
No, in your imagination, you imagine that a child will appear because that's how much you want.
Thank you, Chair.
Just in relation to the problems that exist for children in Ireland today, and there are huge problems that exist for children in Ireland today. Children who are brought up in families of their genetic parents experience the most horrendous abuse and unhappiness in Ireland today. So we have people living in emergency accommodation today who are not being treated properly. So we have a situation in relation to our CAMs where there are waiting lists for children to be seen, to have their unhappiness assessed. So in the context of unhappiness in children, one must look at this as yes, a component of it, but there are so many other components of children's unhappiness in Ireland today that are not being addressed by our state. So, of course, there may be unhappiness in relation to finding out that you were a product of assisted human reproduction, but there are so many other social reasons for being unhappy in Ireland today that it probably is not a priority issue.
I understand. I mean, but what I want to say is that...
Sorry, one speaker, thank you.
What I just want to say is that because there's happiness out there, which there is, I work as an assistant psychologist, there's a lot of difficulties out there and we're trying to grapple with them. But just because happiness is out there, it doesn't mean that it's okay to produce unhappiness.
Thank you. Professor Madden, did you wish to contribute? No. Ms. Rose.
Sorry, I feel like there's a priority to address infertility, which is a form of unhappiness, implicit in this room. But yet, so that's the inability to have your own genetic child. So you provide washed sperm, you provide ICSI, you provide all these different state-funded mechanisms to help people have their own genetic child. But yet, there is no prioritising of that child to have or know their genetic parent. I don't understand why one generation's happiness is seen as so important in this context, while the other one's genetic continuity and happiness is expendable. That seems double standards.
Professor.
Sorry, maybe I'm missing something, but some of the issues that have been raised seem to be predicated on an assumption that the Irish law is not going to provide that information to children. The Children and Family Relationships Act, already enacted in this country, provides that children will have access to the identity of their genetic parents. So we seem to be spending a lot of time today talking about it as if that is not the case. That is already the law here.
No,
it's
at
not
18. It's adult.
At 18, yes.
Adult, that's not children.
As adults.
That's not children.
Yes, as adults.
No, but you said that children would be allowed to access. And
Okay, I apologise. I should say when they reach adulthood.
But the
Children
Convention on the Rights of the Child, as Donnelly in the School of Law in Trinity has done a paper in the International Journal of Law Policy and the Family, and she explicitly refers to Ireland, she's an Irish woman, that the Irish state's justifies the development of telling children at the age of 18, which means telling adults about their parents, that it wished to meet its obligations under the Convention. It was a Joint Committee on Justice, Defence and Equality here in 2014, and she says that she suggests that it's essential that Ireland appropriately translates the requirements of the Convention into domestic law, thereby recognising the right of the donor conceived, in italics, child. So what she's saying, if you're following the United Nations Convention on the rights of the child, not the rights of the child when they become an adult, then children need to know these parents, and I can pass that on. That was this year, 2018.
And I suppose the balancing issue of that in the Irish context is the constitutional rights of parents to decide to be the moral educators of their children, to decide how to bring them up and when to tell them. And I suppose when the Children and Family Relationships Act was being drafted, trying to balance those two competing rights, the legislatures considered that having the right attached at adulthood was preferable than not having it at all.
Thank you very much. Senator Dolan?
No, I'm happy to wait. Senator Dolan wasn't in at all.
Yeah. I've been moved to say a few words. I want to make a statement, an observation, and maybe invite a little response. In my 63rd year, it is my view that the yearning that women have to have a child is very significant, to put it mildly. And when that doesn't happen, it is a cause of deep distress. That's my view of it, yeah. And I didn't get it from a book either. The observation I want to make has to do with Professor Noreen Hayes' opening observations, bottom of page 2. And she's talking about the welfare of the child. Relationships are the primary mode through which children develop, and the effect of the relational process is often more powerful than that of the context where it occurs. And then she goes on and talks about stressors in early childhood can disrupt neurologic, metabolic and immunologic. So I'm not an expert, obviously. Systems leading to poorer developmental outcomes. And then goes on, where parents experience stress through uncertainty or lack of clarity around the security of their role as parents, the environment within the children are developing may be unnecessarily stressful. I'm stopping what I'm saying at that point, and the question about happiness has come up, and that's a nice philosophical conundrum and has been thought about in relation to democracies and all sorts of state systems. But is it to encourage, is there some point, Noreen Hayes, or some comment that you might wish to make when we have been discussing this thing about the distressing nature and the point that's been made here about stressors? They may or may not fit together, but it just struck me when I read back what you had said and listening to what we've been listening to for the last half hour or so.
The context within which I was making that observation had to do specifically in relation to the bill, the surrogacy and the timeline over the counselling process and the final issuing of a parent order. And the observation really was that unintentionally we may be adding to a stressful situation the uncertainties around parenthood that will exist in that space could be could be very stressful for parents, and I'm proposing that that stressful environment is less than conducive to positive early child development. That's merely the point I was making. It was very specifically in relation to the length of time and a suggestion that certainty around parenthood could be made before the child is born. And we had some lengthy discussion about that earlier. It's an optimum, I would suggest, position, because it is recognised that the intended parents are intended to be the parents, and the whole process is towards that. So I was simply suggesting that inadvertently the bill may be contributing to stressful situations for children.
At the start, that I deeply appreciate the evidence and the insights given by all of the witnesses. It wasn't actually my intention to speak so much today. I was trying to hear, and so thank you all very much.
Thank you, Senator. And perhaps Ms. Keegan or Ms. Bernard, in relation to the conversation that we've had in the past half an hour, what's your experience from your organisation?
Well, I think it might be beneficial to actually talk to people who are actually going through surrogacy, and there's a number of surrogacy organisations, okay, because it is very complex, and I think you do need to actually talk to people on the ground in terms of what they actually go through. And there's obviously a lot of legal people who actually represent those people who understand obviously what they have to do on a day-to-day basis. What I would say in terms of kind of what was mentioned in terms of kind of like that we should, you know, like put more of a negative on surrogacy. I don't know how we're going to, if we're talking about a society that's open and then we're turning around saying this situation is happening. So there's people out there who've obviously been born from surrogates, knows the situation, that there's some kind of public campaign where they say, well, really it's not an advisable thing to do. How are those people actually going to feel about their situation? So they're going to be in a situation where they're going to go, well, I'm not going to mention that I was born of this way. I don't want it to appear. So, you know, it automatically puts the shutters up. So you kind of have to deal with the situation there is. And I don't think we're in a society now that's leading to a situation where we're not disclosing thing or non-disclosure. And in terms of kind of when we were talking about Sweden banning surrogacy, I think it would be very interesting to understand why they're banning it. And, you know, what's the rationale behind it? Because I suppose, as you said, you do need a 360-degree review, okay, as to why they're actually doing it. Because, as you said, usually they're quite liberal in terms of their laws. And how do they deal with people who go beyond the country in terms of surrogacy? So how is that? How are they going to? So do they leave the people in legal limbo, or how do they actually deal with that? And also, like, when we were talking about, like, obviously there's a number of countries in Europe that are obviously very legislated. Obviously the UK is one, also Spain is another one. So when we were talking about the medical situation, I mean, I think that is something that has to be dealt with, and I think that is really, really important. So I don't know whether in Spain they would have up-to-date registers of the donors, and whether they always keep up-to-date information in terms of the medical condition, or whether it is a situation where if a situation arises with a particular child where the person who's obviously used donor from Spain, can they ring the particular clinic and find out? In other words, is there access to that information, or is it provided? So I don't know whether we need to kind of look at those situations. Like in Spain, I don't know how long it's been legislated for, but they must be dealing with those situations all the time. So it's a question of how do they actually deal with them? Because I think you are right. People need to have access to their medical information, and particularly on things where it could be preventable. You know, that kind of way, where if they know about it, they can have treatment. So I do think that's particularly important and needs to be taken into consideration, because it's a real thing. Like, if somebody's going into a hospital in Ireland, you know, they need to be able to say, you know, my child has been donor conceived. The doctor may say, well, we need to find out this particular information. Can you go back to the clinic and find, or how do? So that is something that needs to be looked at. So I suppose other regions may have more information on that.
Thank you.
I'd just like to say, I'm so happy to see this legislation coming in. I mean, I've been involved in NISIC for about 20 years now, and when I first started, the technology that we have now, the reproductive technology, wasn't there. And that's just leaping on, and we have no legislation to protect us as patients in the middle of all this. And, you know, it's not just about making us happy, it's about us making our families. And those are the core of our society. And, you know, all we want is the best for the children. So I think good practice, good legislation, I think we can have happy children as a result of assisted reproduction, all types.
Thank you.
So, thank you.
Senator Mullen.
Thank you very much, Kylie. Just one, as I say, just to thank you all again, just for your experiences. I think when people come in here, Chair, who contribute to the best of their ability on the basis of their, as I say, the facts as they know them, whether they're experienced, whether it be professional and academic, whether it be anecdotal, whether it be the fruit of research among many, many people. And I would say particularly when people do it at, you know, when it's not their, if you like, their full-time job, deserve huge credit. And I would not like to see it being the culture in Oireachtas area where people are kind of challenged immediately at first base for whether what they've said is offensive. If they're not setting out to be offensive and they're trying to kind of depict for us certain realities which do involve reflection on people's lived experience, then I really think we as members of the Oireachtas should be very slow to jump down anybody's throat. And I say that regardless of what point of view is being expressed. So my thanks is equal to all of you for what you've had to say here today. Just in relation to the issue of other breaches of children's rights and their welfare in our society. I think you're absolutely right to point that out, Caherlig. I also think, though, that whether it's a priority issue is a matter of judgment. Whether there can be, it's a separate question whether you allow another wrong, notwithstanding that there are already many wrongs in our society. I don't myself hold with a kind of a whataboutery, you know, because that can always be used to divert from the discussion of an issue on its individual merits. And I think that's what we have to do here. And that's why I think there's a real, there's a kind of a prior question here, which is there an injustice involved in any of these procedures? An injustice in terms of the sundering of relationships between children, as we've said earlier. And I think if we're honest about that, we can then proceed to the next question. There may be an honest disagreement. Some may say there is an injustice, others may say there is no injustice, but I think there is a third point of view, which is that there is an injustice, but I believe we should tolerate it. And I would value such honesty, to be honest with you, because I think that's where I personally believe there are injustices here that are so significant that they don't justify permitting certain procedures. But there are other people who would say, I at least agree with you that there is an injustice towards the child here. But I still think that the desire of a parent, etc., to receive treatment, whatever, outweighs that. And I can understand that, and at least we're having a debate on truthful terms. And I hope that's how we can shape it going forward. And I think in the light of today's discussion, and what our last speakers just said, there is a real need to interact at various levels. I've already mentioned how we need to hear and examine and interrogate what research is telling us, what it can and what it can't tell us. Equally, people, as you said, who have been through that experience. I think it's absolutely important, regardless of what people's point of view is. Just as it is important to hear from children conceived through these processes who feel that they have been wronged and that isn't been acknowledged, etc. And I think we should also, Chairman, look comparatively, and so that we're not just, so it's not just me saying I think Sweden is going in the other direction, I think there was a decision in the Spanish Constitutional Court. Let's have a comparative look at what is going on the international scene on this. I would ask, just in relation to, and I think it was Deputy O'Connell that talked about, and others have talked about, well, it's going to happen anyway if it goes underground. I think it's important to remember, for example, this Health Committee issued a unanimous report advocating a prohibition of medicinal cannabis due to unintended consequences and the fact that it would undermine other legislation on parent safety. One of the arguments here is that it'll go underground anyway. So that isn't of itself an argument against prohibitory legislation. But also I would think that in what Dr. Madden was saying, and again, I don't want to put words in Dr. Madden's mouth, but there was an acknowledgement that, okay, it might be the case that anonymous donation is prohibited under Irish law and within the Irish jurisdiction. But of course, there is nothing that is possible to prevent people from travelling to avail of assisted human reproduction involving the anonymous donation. Now, that's an example of it happening underground, okay? I think to some degree we need to acknowledge that the fact that things happen underground or outside of our control is no reason for us not to legislate one way or the other. Okay? But what it does raise is my question, again, going back to what you responded to a moment ago, Gillian, which is this issue of, oughtn't we discourage that much at least? If we have an architecture allowing assisted human reproduction, including surrogacy, and it hasn't gone through the Oireachtas yet, so, hopefully, I'm hoping that other arguments will prevail. But let's say I'm wrong, and let's say it does happen. Or let's say I don't persuade, and it does happen. Would people agree that that should be discouraged? In other words, going abroad to avail of surrogacy through anonymous donation. I'd like to hear what people think of that. Dr. Madden, I think, may have left the room when I asked the question about, I pointed to my dissatisfaction with the obligation being on donors. I don't know if you were here for that, Dr. Madden, to keep the register updated with relevant information. For example, if they are diagnosed with health conditions. And I just felt that that's going to be honoured more in the breach than in the observance, and that surely the obligation should be on clinics and providers here to maintain, that they would be legally responsible for having all relevant information, which could be set out in legislation or in a statutory instrument, that they would be legally responsible to maintain contact with donors for the purposes of securing sharing important relevant information, including information that goes to health issues and so on and so forth. And I would appreciate your view on that. And the related question, because as I understand it, there's nothing in the scheme to allow donor-conceived children to easily trace their genetic parents or half-siblings. So again, should there be something in the scheme that actually makes it more easy for donor-conceived children to trace their genetic kin, be it in Ireland or overseas? Finally, and I don't think it's a matter we'll get to today, but perhaps it's an issue for another day's reflection, the whole area of all of this presumes activity which is destructive of human embryos in one way or another, the way assisted human reproduction is practiced in the world today. I have, and others have, problems with that. I think many people would have problems with the saviour sibling concept that you have in Britain, I think, for a good many years now, where basically children are brought into the world for the purposes of, well, not brought into the world, but that embryos are created and for the purposes of treating an illness or a condition. It was, I think, Baroness O'Cahan who spoke very critically of that in the British House of Lords. It's probably an area we need to look at another day. It's a very controversial aspect of this this whole area of human endeavour, and I don't think it's something that's covered by the bill, but I think it is something that we need to have a debate about.
Thank you, Senator Mullen. Professor Madden.
So certainly in relation to the issue of the maintenance of up-to-date health information on the donor, I agree. I think there should be an obligation on clinics to maintain that information insofar as they can. I mean, obviously there may be situations where they are unable, despite their best efforts, to maintain contact with donors, but they should certainly, I think they should, there should be an obligation on them to do that insofar as they can. I think it's important that children who've been born through donor conception and their parents should have access to that information as required to help them with medical issues that might arise. Absolutely agree with you on that. Yeah. Was there a second question?
The issue of tracing, that the scheme ought to provide that people would have the ability to trace their genetic kin.
Yeah, that is provided for in the Children and Family Relationships Act, as far as I know. It just hasn't been commenced.
In other words, what, the clinics must cooperate with them?
That there would be a situation where I suppose that the children who are born, and there would be a limit on the number of children who would be born from a donor, obviously as well, which is important, particularly in a country the size of ours, that there would be a limit put on that by the regulator, whether it be 3 or 5, depending on, I suppose, the number of people who would be expected to be using that service and geographical spread and so on. I think that there should be a possibility through the registration system that children born through donor conception, at whatever age it is considered appropriate through the legislation, whether it be through childhood or adulthood, and I don't have a particular view on that, that they should be able to, through the register, have contact with genetic siblings, if of course the other siblings are in favour of that. Was there another question?
No, I don't think so. I think that was, yeah, I think Dr. Rose wanted to offer on that, but no, thank you for your answers.
As far as I'm aware, there's nothing retrospective in terms of providing, I mean, at least after my court case, part of the settlement was a retrospective gene library and support service. And obviously with Norell's law and the new legislation in Germany, the overturning of anonymity retrospectively is what's happening. So that needs to be looked at, and funding for counselling for those people when they go through those experiences, including for people who've been used as donors, because the impacts then on their wives and their families can't be, not everybody knows what the impacts are, but those impacts are unravelling over time, and it's not always as simple. Some people have gone into this thinking it's like blood donation, and then they're meeting children that look just like themselves, and that, or adults that look just like themselves or like their own mothers, and that can have a huge impact on them and the families that they have. So you need to have appropriate support that aren't infertility counsellors, people who understand those kind of scenarios, like in adoption.
Thank you very much.
It will be hit for maintenance in 20 years' time. And we'll see.
Thank you, Senator. To conclude, Deputy... Deputy Durkan.
No, I just want to correct something there. I know that Senator Mullins has been a pains not to put words into anybody's mouth. I wouldn't like the committee's mouth to be loaded either. But I want to clarify one thing. This committee did deal with the cannabis bill, and we came to conclusions based on medical evidence, which was strongly presented, and on the basis that the proposal that it was a gateway drug that required medical supervision, and they emphasised the medical supervision right from the outset, and that wasn't going to be available, and that wasn't accepted, and that there were several precedents in this country which clearly pointed out to situations whereby, in the absence of medical, or once the medical approval came, or the committee's approval came along with it, automatically then the state becomes liable for anything that goes wrong afterwards. And I
just don't want to go down the
No, I don't want to go down that road. It's already been travelled.
It's already
been travelled. One other one, Chairman. One other one. Common references, you know, that hard cases make bad law. Hard cases make bad law. Lack of law sometimes leads to desperate cases. And in the annals of our history, there are sufficient desperate cases to be able to assure us, you know, that we should investigate insofar as we can, and we should legislate to the best of our ability, having received and learned all the evidence. And the very last point I want to make is this. There is no way we can prevent people from travelling outside of this country, for whatever purpose, nor should we. For the simple reason is this. That's already been determined in the constitutional referendum in this country, despite the efforts on the part of some people to suggest that we could. An appalling conclusion to have reached even in those days. Thank you, Chairman.
Thank you, Deputy Durkan. Thank you very much. So, on behalf of the committee, I would like to thank our witnesses for coming in to give evidence this morning. It is obviously a very complex area. I do not think this will be the last meeting we're going to have in our pre-legislative scrutiny of assisted human reproduction. I think the debate has been very informative, robust at times. We have to take all the viewpoints on board and distill them and come up with a piece of legislation. So thank you very much, Emer O'Reilly, Joanne Rose, Deirdre Madden, Noreen Hayes, Marion Bernard and Gillian Keegan. Thank you very much. This committee is now adjourned until Wednesday the 16th of January 2019.